Made business here, Lordship. Lordship, I would like to mention this one case for listing IA, Lordship. This is for stay because execution proceeding has been started, Lordship.
When?
Tomorrow, Lordship, it will come for orders.
Okay.
At your place, Lordship.
Yeah, please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 5, Lordship. Lordship, in this matter, Lordship, my senior Mr. A. Sharma is appearing, who is also the standing counsel of Oil India Limited, Lordship. And he is out of station.
What is your name?
W. Rahman.
Mr. W. Rahman, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed 26th of May.
Hello.
May I please, Lordship? Lordship, I beg to mention listing and CRP IO, Lordship, on Monday, Lordship. CRP
When have you filed?
Lordship, yesterday.
So it will be automatically listed on Monday. For mentioning is not necessary. If it does not get listed, then you mention.
My future Lordship. Lordship, with the consent of other side, I beg to mention item number 11, 30, 31, 32, Lordship. My senior 11.
11,
30,
13,
31 and 32, Lordship. My senior
31.
Mr. S.K. Goswami is out of station, Lordship. I'm praying for some
And
accommodation.
Mr. R. Sharma, learned counsel for the appellant, who seeks an adjournment on the ground that the conducting counsel for the appellant is out of station. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
I'm praying for a particular date, item number 11. That was the on the ground on which the consent was sought.
Item number 11 at the date
2nd
June.
Lordship.
Oblige, Lordship.
Deeply obliged.
My lord, I beg to mention item 6 and 7. I'm appealing for the respondent, consent of the other side, the appellant side.
Who is appearing for?
I'm for the appellant.
Heard Mr. H. Moria,
For the
learned
respondent.
counsel for the respondent, who seeks an adjournment. On what ground?
My lord, actually, my file is missing, my lord.
On ground
I
of
have-
personal difficulty. Also heard Mr.
See, go for the
C. Gogoi appearing for appellant, who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
My lord,
Yeah,
30, if possible, 30 April, 30.
No. 28 May.
Any date before the 15th of May, because there are some.
Some advocate is likely to come from Madhya Pradesh.
Yeah.
15 May. 15 strike.
55 or above, any date.
14th May.
May please your lordship, I beg to mention for listing 2 RSA for hearing. One is for
Hearing in this manner, it will not be listed.
on June, my lord.
It will come in orders column and then it will go.
Hearing matter, my lord.
Hearing
In the month of June, my lord. First week of June.
2nd of June.
Make believe Lordship, I'm praying for listing my lord for order in order column, my lord, in MSc appeal, my lord. Monday, my lord, on Monday, my lord, because it's 2024, my lord. We have filed 2024.
Why in orders column?
My lord, for delay of condemnation, my lord,
Okay.
on
Not
Monday,
in-
my lord.
not on Monday. 6th of April.
Too late, my lord.
We are full with cases. 6th of April. You have to wait.
Please, my lord.
May I please, Lordship? Lordship, I beg to mention for listing of the IA, Lordship, in bail application number 7662/2026, Lordship. What happened in this case, Lordship? This petitioner, mother died on
Bail application, this is not the roster. You have to,
second bail application. Which I move on, Lordship, the Yes, Your Lordship. Whatever, in this case, Lordship, that petitioner mother died.
Father
Yes,
died,
yes,
okay,
Lordship,
okay,
mother.
when you want.
If it's possible, Lordship, today, because 29 Sarto ceremony is there.
Tomorrow,
Yes, yes,
tomorrow.
tomorrow is, I'm grateful, Lordship.
May it please your lordship, with regard to item number 25, I pray for upgradation of the said item lordship because long back we have filed an IA for early hearing and the matter could not be reached, a duty prosecutor matter could not be taken up on the earlier occasion.
What will happen to the other cases which is listed in before you? We have to examine each and every case.
Lordship,
So no upgradation, you have to wait.
lordship. Much.
May it please your lordship, lordship, I beg to mention item number 20 with the consent of the other side. Due to some personal difficulties, we are unable to conduct this case today.
Miss M.
Okay,
Sakya,
yes,
learned counsel for the appellant,
appellant lordship.
appellant who seeks an adjournment on the ground of personal difficulty of the conducting counsel or the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same, hence the prayer is allowed. Let this matter be listed. 28th May.
Obliged lordship.
May it please your lordship, with due consent from other side, I beg to mention item number 15 of today's list, your lordship. We are for the respondent in this case, your lordship. Conducting counsel has some difficulty, your lordship.
Miss P. Bhattakur, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed the learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer.
Next week, any date lordship.
Yes. 28th May.
28, 28.
28th May.
Okay. Lordship 28, some difficulty lordship.
Some other day. 2nd June.
Obliged.
May it please your lordship, I beg to mention for listing for RSA for orders matter before due vacation.
Orders. 6th April.
Deeply obliged, my pleasure, lordship. Lordship, in respect of item number 5, lordship, I have already mentioned, lordship, there is an interim order, lordship, that may be continued.
Item number 5, interim order shall continue till next.
Hello.
Should I beg to mention item 13 of today's daily list? I appear on behalf of Mr. B. Sharma for the railway lordship, and he appears for the appellant lordship.
On behalf of D. Rathi.
Appearing for an
Item number
adjournment.
13.
1-3.
Yes, your lord.
1-3, somebody has 3-0. Okay. Heard Mr.
I am MP Sharma. I appear on behalf of Mr. B. Sharma for the sole response.
MP Sharma appearing on behalf of Mr. B. Sharma,
Yes, sir.
learned counsel for the sole respondent, who prays for an adjournment. Stop. Learned counsel for the appellant does not oppose the said prayer, hence the prayer is allowed. Let this matter be listed. 28th May.
Your lordship, can it be listed on the first week of May? It's an old matter.
No.
Your lordship, I beg to mention listing of 3 MFA.
In orders column.
Yes, your lordship, after due vacation. Any date may be after.
21st April.
Obliged.
May it be pleasure, lordship. Lordship, I beg to mention for listing 1 MFA in hearing column, it's a old pending matter, my lord, in the year of 2015. Lordship, any date after due vacation?
28th May.
Obliged.
So please your lordship, lordship, I beg to mention for listing of 2 IA lordship for early hearing. On Wednesday lordship,
24th April.
lordship, before that lordship,
No, next week Didi Papare. 1st of April.
obliged lordship, please your lordship, I beg to mention 1 IA civil in RSA for listing in orders. Lordship,
6th April.
6th April. Yes, lordship.
We getting PA item 27 from supplementary list.
May I please tell us? My lord, I filed additional affidavit, my lord. I will kindly have a look this additional affidavit.
Yes, where is the additional affidavit?
Yesterday I have filed my lord. And your lordship directed to take this additional affidavit today, my lord.
It is not on record.
My lord, kindly take about two, my lord. By this time.
We have some difficulty, lordship.
Kindly take about two, my lord.
Tomorrow.
Otherwise, extra copies I have, my lord.
You have the copy of additional affidavit.
No, lordship. We do not.
Tomorrow.
Tomorrow.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit which is not placed on record. Therefore, he prays for calling of the said additional affidavit. Stop. Registry is directed to place the additional affidavit filed by the petitioner along with this record and list this case again tomorrow, that is on 27th of March.
Lordship, may I make a mention of item number 35, lordship?
35.
35, lordship, we are just a formal party, lordship. This relates to quashing of a DV proceeding, lordship. We have been made a party, lordship.
Quashing of a,
DV proceeding, lordship, domestic
okay,
violence proceeding.
you may not be required.
Lordship, that's okay.
Extra copy, my lord, and sign.
Item one.
The appeal is yet to be admitted.
Lordship, yes.
We'll admit it.
Lordship,
We'll admit it.
yes. For hearing. It is, lordship, it is against the
It is already admitted.
already, yes, yes, lordship. It is already admitted and they have also filed their this objection. Today it should be.
So why it has come in admission
Yes,
column?
yes, lordship.
It,
It is in the hearing column.
it should have come in hearing column.
Hearing column.
We'll list it for hearing.
After view, lord.
Yes. Heard Mr. Darakulla, learned counsel for the appellant. Also heard Mr. M.K. Das,
MK Bora.
sorry, M.K. Bora, appearing for the sole respondent.
Yes.
Sole respondent. It appears that this appeal was already admitted on 5/2/2025 and it is ready for hearing. Trial court records would be necessary.
It is there.
Okay.
Already.
Release this matter for hearing on 2nd of June.
May not.
May, it will be difficult. 2nd of June.
Oblige.
Item 26 for supplementary list.
May it please, your lordship.
Yes.
Lordship, will kindly see page number 24. Basically, my lord, we are agreed with this order, my lord. Where, my lord, a claims petition, my lord, was dismissed without even issuing notice, my lord. Page number 24, my lord.
Yes.
May I read it, my lord? Learned counsel for the claimant has filed Hajiran. Upon perusal of the claim petition, it reveals that the claimants and OP number 1 and 2 are residents of Komalpur in the district of Kamrup, Assam, and the accident also took place within the jurisdiction of Kamrup. Further, there is no office of Tata AIG Limited in the district of Borpeta, and the claimants have not submitted any documents showing that they are presently residing within the district of Borpeta. Hence, the claim petition is hit by section 166(2) of the MVAC, and as such, this claim petition is dismissed for want of jurisdiction. Now, Lordship will kindly see our claim petition, my lord. It is at, my lord, page number 8. If your lordship will kindly see the cost title, my lord. Bottom, my lord. All are residents of village Komalpur, PO Puthimari, PS so and so, and presently residing at village Burikamar, PO Bagodi, PS Sorthebari, district Borpeta. And lordship will also see.
Claimants are resident.
Yes, presently residing, my lord. And lordship will
But
also.
to Invoke jurisdiction,
Three
defendant,
places, my lord,
yes,
where the office of the defendants are there, my lord. Second is that, my lord, where the accident took place. Third is where the claimant was presently residing. As per 166, my lord. And lordship will also see page number 15, my lord. It's that it is also hereby mentioned that the parental house of the claimant, Miss Mira Begum, is at village so and so, district Bortata. Now, my lord, the thing is that even, my lord, if we accept that, my lord, the claimant had no residence, then also, my lord, for lack of jurisdiction, at best, my lord, the tribunal would have returned the claim petition, my lord, or could have transferred it. My lord, it is no way, my lord, at the very threshold, my lord, this should have been done, my lord, that the claim petition should have been dismissed. Whereas, my lord, this is nothing but a beneficial legislation, my lord. And my lord, the learned tribunal should not have, my lord, stick to this technicalities, my lord, and dismiss the claim petition at the very threshold, my lord, without even issuing notice to the respondents. Had the respondents arrived,
MBA.
but if the respondents have appeared and in their written objection, they would have taken that, my lord, then, my lord, the tribunal below could have framed an issue on this and decided that issue either, my lord, as a preliminary issue or a final issue, my lord. But without doing that, my lord, on the very first day, if lordship may kindly see 166.
Yes.
Two, my lord, every application under subsection 1 shall be made at the option of the claimant, either to the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within the local limits of whose jurisdiction the claimant resides, or carries on business, or within the local limits of whose jurisdiction the defendant resides,
Okay.
and shall be in such form and contain such particulars as may be prescribed. So, but categorically, it has been mentioned that the jurisdiction where the claimant resides or carries on business, my lord. So, my lord, there is a categorical statement in the claim petition itself that the claimant was presently residing in Borpeta, my lord, in a paternal house, my lord. And it's a death case, my lord. So, perhaps, my lord, the learned tribunal was too hurried up in, my lord, deciding that, my lord, without even issuing notice or hearing the other side. But because, my lord, it is a case of, my lord, territorial jurisdiction, my lord. Now, jurisdiction are of three types, my lord. Territorial, pecuniary, and subject matter, my lord. But pecuniary and subject territorial, my lord, they do not
Okay.
go to the root of the matter, my lord.
You have not submitted any document showing. That was one ground.
This is made
Oh.
affidavit, my lord, on oath, my lord, we are making.
Yes.
And it can be so that, my lord, the other side.
Then we have to examine.
My lord, my humble submission is this, my lord. If this matter can be remanded back.
That I was thinking.
Yes, for a
But-
decision
but-
appraised, my lord.
But as the court has given some opinion
Yes.
that no materials was there.
But it has been made on affidavit, my lord, on oath, we have made that statement, my lord. And, my lord, if it is decided on merit, my lord, it will take at least, my lord, 2-3 years. Then again, my lord, if it is allowed, again, we have to go back and, my lord, start the trial afresh. It's a death case, my lord. And I have also some judgments of the Honorable Supreme
No,
Court,
without issuing notice,
my lord,
we'll call for the records.
my lord.
And next date, we'll peruse the record and decide the matter. Because tribunal has not issued notice to the,
Yes,
so we are not issuing notice to the
Minor.
respondent. We are only calling for the.
Minor.
Heard Mr. S. Das, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellants impugning the order dated 29/11/2025 passed by the Motor Accident Claims Tribunal Barpeta in MAC case number 375/2024, whereby the claims petition filed by the present appellants under section 166 of the MV Act, 1988 was dismissed by the tribunal on the ground that it is hit by section 166 within bracket 2 of the MV Act as and that the claims tribunal Borpeta, Motor Accident Claims Tribunal Borpeta does not have jurisdiction to entertain the aforesaid application. Learned counsel for the applicant has, learned counsel for the appellants has submitted that the cause title of the application filed by the present appellant under section 166 of MV Act before the claims tribunal itself indicates that all the claimants / appellants are the residents of district Borpeta and were presently residing in district Borpeta at the time of filing of the claim petition. He submits that under section 166 within bracket 2 of the MV Act, the claims tribunal in Motor Accident Claims Tribunal in whose jurisdiction the claimant resides or carries on business does have the jurisdiction to entertain an application under section 166 of the MV Act. He therefore submits that the impugn order was apparently wrong and contrary to the statutory provision. He submits that even the claims tribunal has even not issued notice to the respondents and had dismissed the claims petition without taking into consideration the statutory provision which empowers the which entitles the present petitioners, present appellants to file the claim petition before Motor Accident Claims Tribunal Borpeta. I have considered the submissions made by learned counsel for the appellant. On bare perusal of the impugn order as well as the cause title of the application filed by the present appellants under section 166 of the MV Act before the claims tribunal, it appears that prima facie that the impugn order appears to be erroneous. However, as the claim petition, however, as the claim petition filed by the present appellants were dismissed by the Motor Accident Claims Tribunal by making an observation that claimants have not shown any documents showing that they are presently residing in the district of Borpeta. comma. This court intends to peruse the records of the MSC case number 375/2025 before passing any orders in this regard. Hence, let the records of MSC case number 375/2024 be called for from the Motor Accident Claims Tribunal, Barpeta. The registry shall take steps for requisitioning the aforesaid records. Let this case be listed again on.
Can it be kept as part of mine?
No. I have clarified everything in the record. Let this case be listed on 15th of May.
Highly obvious.
Order, item 2 and 3.
नहीं,
My lord, in item number 3. He will be appearing for the insurance, my lord. I will pray, my lord, that my lord, she may accept the notice, my lord, that this on item 3, my lord, entire steps will be over. For 1 and 2 responding, my lord, he is appearing.
And item number 1, item number 2,
Item number 2, I am appearing.
For
or
the private respondents, my lord, driver and owner, I can have the, my lord, I can appear, but presently I don't have the authority, but I will file my wakalat, my lord. In item 2.
and item number 3,
3, my lord, I am for the appellant, my lord. She will be appearing for respondent, my lord, 1 and she will be for 2. So let it come.
both these cases are arising out of same.
Yes, my lord. In item 2, my lord, the claimant is praying for enhancement of the award, my lord. In item 3, my lord, the owner and the driver has preferred the appeal. Because, my lord, while adducing evidence, my lord, the driving license could not be, my lord, annexed along with the written statement. Though statement was made, it was also stated that it is enclosed with the WS. But the tribunal found that, my lord, it is not there in the record. So accordingly, the owners was an entire liability was, my lord, casted upon the owner and the driver. They have a valid license, my lord, as well as insurance.
Okay. Separate order लिखे. In item number 2, heard Mr. M.P. Neog, learned counsel for the appellant. Also heard Ms. L. Sharma, learned counsel for respondent number 3. Stop. Mr. B. Gogoi, learned counsel, appears that he is ready to accept notice
1 and 2.
on behalf of respondent number 1 and 2. You have received the
OP, my lord, he will serve to me, my lord,
Yes.
he will report.
The appellant is directed to furnish copy of memo of appeal along with annexures to the engaged counsel for respondent number 1 and 2. The appearance of parties is therefore complete in this case. The MSC case I see.
A45.
Huh? I see. Okay. It appears that the records of MSC case number 18/2022 has already been received, and therefore this appeal is ready for hearing. Let this matter be listed for hearing 4th of June. In item number 3, heard Mr.
I pay for the appeal.
B. Gogoi appearing for the appellant. Also Mr. M.K. Neog appearing for respondent number
1.
1 and 2. 1 and 2.
1 and 2, as well as Miss
L.
L. Sharma, who accept notice for respondent number 3.
2.
The appellant shall furnish copies of memo of appeal along with annexures to the respondent number to the learned counsel for the respondent. The appearance of parties is complete and the records of the concerned MSC cases has also arrived. Hence, list this matter for hearing along with MSC appeal number 514/2024 on 4th of June.
Item 28 of supplementary list.
Lordship, as per office note dated 25/3/26, AED card for respondent 4 and 5 has not been received back yet. And postal report could not be tracked as the data of consignment has been removed from data bar. TCR received, Lordship.
Then you have to take fresh steps.
But AD has not yet come, Lordship.
When have you taken steps?
We had taken earlier, Lordship, in 2025. So we can take, okay, Lordship.
I am appearing for respondent number 1 and 3, madam. 2 already expired. May I pray that let the appellant be directed to go for paper publication instead of ADs and all, madam. That would be
Lordship,
better, I think.
Lordship, problem is paper publication. Once paper publication, they are owner and driver, and we are challenging that they are liable to pay the compensation. So, but Lordship directs, we can take paper publication. That is the issue, Lordship.
No, you can take,
But I think they are from the same family, Lordship, because at least the owner, respondent number 4, Lordship, he is same same title and same village, Lordship, Lakhimpur.
Well, since
Then I can,
hold on.
as Lordship.
No, because trial court record is before your lordship.
okay, then take, or you can once try by speed post.
Then the tracking will be there.
Then we'll get the tracking.
Fine,
Or
Lord.
we'll give a fixed date, short date.
Otherwise, I'm ready for hearing, Lordship.
My lord, one
Uh,
small prayer, my lord.
Yes.
I have filed an IA, my lord. They have deposited 50% of the awarded amount. That should be released in favor of the
Lordship,
appellant.
on that same ground, yesterday I had a hearing in one of the IA, Lordship.
Okay, let the notice be served on
Yes.
driver.
My lord, may I may. My lord, Supreme Court is very clear about the
We'll fix a short date. On that day, you may make your submissions. Heard Miss Adi Majumdar, learned counsel for the appellant. Also heard Mr. H. Das, learned counsel for respondent number 1. 1, 2, and 3.
1 and 3, 2
Two
expired,
expired,
my
three
lord.
was striked out.
1, 2, 1, and 3. It appears from office note dated 25/3/2026 that the notices issued to respondent number 4 and 5 have not yet returned. Neither the AD cards have been received back. Under such circumstances, the appellant is directed to take fresh steps for issuance of notice upon respondent number 4 and 5 by speed post within 7 days from the date of this order, returnable April of the 27th April. List accordingly.
I'll apply.
Item 4.
Last order को
Let please, your lordship.
When it was listed last,
Last listed lordship. Last listed lordship. On Tuesday, lordship.
okay. Tuesday, there was no hearing. Yes,
The matter was heard on Monday and then it was listed on Tuesday
yes.
and today, lordship.
Briefly refresh the matter.
Lordship, this case was about two submittees. The case of the appellant was that they belong from Narayangaon and the submittee was in Narayangaon. And that's why the submittee, the land should be of the submittee belonging to Narayangaon. Our case was that we are people from Tinipukuri and we had we were running a submittee in Narayangaon.
And what trial court did?
Initially the trial court held the decree in their favor. Then we have challenged that before the civil judge, and civil judge has decreed the suit in our favor. They have dismissed the suit, lordship. Against that, they have filed this appeal.
Okay.
Now, lordship had a query. The query was whether the suit is a suit filed in representative capacity.
Yes.
And could it be filed under Order 1 Rule 8? Applicability of Order 1 Rule 8.
Yes.
Now, if I may just read the appellate order, then lordship would refresh, lordship.
Yes, yes.
Lordship, there are two major substantial question of law which was framed, lordship. Number one, whether the learned appellate court is correct in holding that the plaintiff has no right, title, and in possession over the suit land. Number two, whether the learned appellate court is correct in holding that the suit is not maintainable while deciding issue number 1 in view of Order 1 Rule 8.
Okay.
Now, lordship, I'll just come to the first substantial question of law and then I will deal with the second one, lordship. Lordship, before reading the appellate court judgment, I would just read a little bit of the trial court judgment once.
Yes.
Lordship, may kindly peruse page number 35. The judgment starts from 36. I would just read the facts, then lordship would be clear, lordship.
Yes.
The plaintiff's case is that he is a chairman of Narayangaon Unnayan Committee. Narayangaon and Tinipukuri are two different revenue villages of Paschim Bonbhag Moza within the district of Nalbari. After constitution of BTAD, Tinipukuri was included in Baksa district. The BTAD and Narayangaon remained within Nalbari district. The land described in Schedule Q is a reserve land situated in Narayangaon. Within this reserve land, the land described in Schedule Q was converted into periodic patta, land being numbered as patta number 146 and dag number 1001 covered by 21 bighas, 3 kothas, 10 lesas, and periodic patta number 176 consisting of dag number 1002 covering 14 bighas, 2 kothas, totaling 36 bighas, 10 lachas land, which was referred to as the suit land. After conversion of land into periodic patta, Narayangaon Sarvodaya Seva Mandir was mutated in the revenue records and therefore it has its own status. The people of Narayangaon had established different institutions for their all-round development, such as primary healthcare, so and so.
It was mutated as Sarvodaya Seva Mandir, Narayangaon.
Initially, I'll come to that. That was a wrong because of the name, it was a wrong confusion. It was later rectified by the deputy commissioner. I will come to that, which is apparently in this part of the record and evidence is laid on that, and the appellate court has rightly decided that. I'll just next lordship. What is the case of the plaintiff?
is within the co-scheduled land, there is a road approach proceeding in east-west direction. And in both sides of the land, the people of Narayangau have established business, stalls, shops, etc. On the pretext, the Narayangau Sarvodaya Hema Mandir was earlier instituted by the village of Tinipukhuri. Defendants have started to claim the institution as Narayangau and also interfered with the development work, including digging fishery pond was granted, which was granted to Narayangau. So that is there basically that we have started interfering with the Narayangau Sarvodaya Hema Mandir.
Yes.
Now, Lordship may kindly skip all these, Lordship, and come to what is the case of the defendant in page number 37. Page number 37, para number 6. The defendant contested the suit by filing written statement containing inter alia there is no cause of action, that the suit is not maintainable and the suit is barred by non-jointer. The defendant stated in the written statement that the allegations made by the plaintiff are false and baseless. The defendant stated that BTAD is not a separate state and village Tinipukhuri is still within Paschim Bonbhag Moja, and the Mojadar of Paschim Bonbhag Moja have collected revenue from the people of Tinipukhuri village. The defendant stated that the scheduled core land is not a reserve land. The people of different village of Paschim Bonbhag Moja, with the aid of the government, has instituted several different society educational institutions. The defendant also have a Tinipukhuri Sarvodaya Hema Mandir, which was established under the management of the defendant and which is registered under government from several years. The defendant stated that the scheduled core land is not mutated in the name of Narayangau. The name of Narayangau has been misprinted with the name of Sarvodaya Hema Mandir in the revenue records. The defendant stated that the real fact is that the Tinipukhuri Bhudan Gramdan village was constituted in the year 1961. The Sarvodaya Hema Mandir Tinipukhuri was established and registered under the Societies Registration Act under Assam Sarvodaya Hema Mandal, which was managed by Assam Bhudan Gramdam Board, which is an inspiration of Mahatma Gandhi and Acharya Vinoba Bhave. The Sarvodaya Hema Mandir is situated upon 43 bighas 1 kathas land of Narayangau village, Paschim Bonbhag Moja, and the aforementioned land is under occupation of Sarvodaya Hema Mandir Tinipukhuri from the year 1963, and they have been paying revenue regularly. The defendant are the office bearers and members of the Sarvodaya Hema Mandir. A large number of weavers are weaving under the Sarvodaya Hema Mandir, and people are cultivating upon the cultivatable land under the Sarvodaya Mandir, and produce of the cultivation is used to run 2 schools. The defendant stated that the plaintiff has filed this suit by misleading the court, hence the suit is liable to be dismissed. Now, Lordship, these are the issues, Lordship. 3 and 4 issues are with regard to the right and title, Lordship. That Lordship may kindly come at first, Lordship. In page number 40, the issues 3, 4, and 5 has been decided. Lordship may kindly come to page number 42. That is with regard to what the PWs has stated. In support of the claim of the plaintiff, adduce oral as well as documentary evidence. But this is absolutely wrong. There is no documentary evidence filed by the PWs. That may be noted, Lordship. Plaintiff adduced oral evidence of 4 witnesses. The witnesses, the PWs supported the case of the plaintiff. PW1, Abdul Kader, is the plaintiff. During his cross-examination, he stated that the office of Sarvodaya Hema Mandir Tinipukhuri is situated in the village Tinipukhuri. He specifically denied the suggestion that the defendants have been in possession of 43 bighas under DAG number 1001 and 1002 in the name of Sarvodaya Hema Mandir. So he has stated that there is we are not a resident of we are not running the Hema Mandir in Narayangau. Now, similarly, the PW2 has also stated the same thing, and PW3 has also stated the same thing. Now, Lordship may kindly come to page number 43.
Yes.
Now from the 1, 2, 3, from the seventh line, Lordship, from the top.
Yes.
The defendant also have a Tinipukhuri Horbodoya Heba Mandir, which is established under the management of the defendant and which is registered under government for several years. The defendant stated that the scheduled call land is not mutated in the name of Narayangao, but the name of Narayangao has been misprinted with the name of Horbodoya Heba Mandir in the revenue records. The defendant stated that the real fact is that the Tinipukhuri Bhudan Gramdan village was constituted in the year 1961. The Horbodoya Heba Mandir Tinipukhuri was established and registered under the Cooperative Societies Act under the Assam Horbodoya Heba Mandal, which was managed by the Assam Bhudan Gramdan Board with the inspiration of Mahatma Gandhi and Horbodoya and Acharya Binoba Bhave. So this is what has been stated by the defendant, the DW1 Lordship. Now, Lordship may kindly come to page number 44. What happened during the course of trial? One commission was established to show who is in possession of the land. That Lordship would find in page number 44. Para number 24.
Yes.
During the course of trial, a commission was also issued for a local inspection of the suit land. The circle officer Gograpa Revenue Circle was appointed as commissioner to determine the possession of the parties. The report of the commission suggested that the suit land is situated within the village Narayangao of Pochim Borbhag Moja under Gograpa Revenue Circle. The public institutions such as Horbodoya Heba Mandir, number 17 number Alia Gaon Panchayat, Tinipukhuri Acharya Binova Vidyapit ME School, Anganbadi Center, Horbodoya Jatiyo Vidyaloy Acharya Binova, Durga Mandir, Narayangao Chowk Bazar are found to be situated in Narayangao, are being public institutions and managed and looked after by the people of Narayangao, Nomati, Boralkuchi and Tinipukhuri village together. So, Lordship, the CO's report never said that the plaintiff is in possession of the suit land. It is said that all the people are running all these institutions of 3 villages combined.
Yes.
The Tinipukhuri village was under the administrative jurisdiction of Gograpa Revenue Circle till December 2013. But after reorganization of the circles, it was excluded from Gograpa Revenue Circle and it is included in BTAD. I have gone through the pleadings and evidence put forward by both the parties. I have also perused the exhibits of both parties and from the report of the commission. On carefully going through the submissions of the parties and the evidence available on record, it appears to me that Tinipukhuri Bhudan Gramdown village is constituted in the year 1961. The Horbodoya Heba Mandir Tinipukhuri was established and registered under the Societies Registration Act 1860 under Assam Horbodoya Heba Mandir, which was managed by the Assam Bhudan Gramdan Board with an inspiration of Mahatma Gandhi and Acharya Binoba Bhave. The Horbodoya Heba Mandir is situated upon 43 bighas 1 katha land of Narayangao village, Pochim Borbhag, Moja. Till constitution of BTAD, the local people of Narayangao and Tinipukhuri were managing the public institutions, including the Horbodoya Heba Mandir.
Last time you submitted that this observation was without any basis. The people of Narayangao.
Lordship, I given an analogy, Lordship. I'll come to that. Let me read this, Lordship.
Okay.
After bifurcation, Tinipukhuri village was included in BTAD, whereas Narayangao remained in Nalbari district. The people of Narayangao has been managing the affairs of public institutions, including Horbodoya Heba Mandir till date, which is revealed from the report of the commission. Now, this, from where they have got it, Lordship, I do
This
not.
was without basis.
This was without basis, Lordship.
Okay.
Now again, the suit land including Horbodoya Shiva Mandir is situated over Narayangao, which is not a Gramdan village. The Horbodoya Shiva Mandir, which is established under Gramdan board, has to be situated upon a Gramdan village as it is managed by the Bhudan Gramdan board. But the present suit land, including the Horbodoya Shiva Mandir, Pochim Bonbhag Moja, is situated upon Narayangao, which is not a Gramdan village. As such, in my considered opinion, the defendant being a resident of Gramdan village Tinipukuri have no authority over the people of Narayangao and the institution is situated upon Narayangao. Revenue records also reveal that the suit land is mutated in the name of Horbodoya Shiva Mandir Pochim Borbhag Moja. Hence, it appears to me that Narayangao Unnayan Committee, represented by the plaintiff, has right title, interest, and possession over the suit land described in constituted land, and Horbodoya Shiva Mandir village, Tinipukuri, managed and represented by defendant, do not have any right and title and interest and possession over the suit land described in Schedule Q land. Now, how can such a observation be made, Lordship? The plaintiff.
What was the observation by the appellate court in this?
Lordship, I'll come to that. Lordship, may kindly come to page number 15, Lordship. Lordship, got it?
Yes.
The two issues, issue number 3 and 4, has been decided together. Whether Narayangao Unnayan Committee, represented by the plaintiff, has right, title, and interest over the possession over the suit land, or Horbodoya Shiva Mandir, Tinipukuri, managed by the defendant, has right, title, and interest and possession over the suit land described in Schedule Q. The plaintiff has filed a suit in a representative capacity as the president of Narayangao Unnayan Committee, claiming declaration, right, title, and interest and possession over the suit land described in Schedule Q of the plaint. The plaintiff in the plaint has claimed that the land described in Schedule Q of the plaint is a reserve land of Narayangao village, and the local people of the same village set up many institutions as religious institutions in the name of Horbodoya Shiva Mandir. Before Constitution, Lordship, I'll just skip all this because we have already read this, Lordship.
Yes.
Lordship, kindly come to page number 16.
16.
It starts 1, 2, 3, 4, 5, 6, 7, 8. From the 8th line, Lordship.
Yes.
Defendants are members of Horbodoya Shiva Mandir Tinipukuri and are running the said organization since 1966. He does not know in which year Horbodoya Shiva Mandir Narayangao was established. He cannot say, that means that PWs, Lordship, it is they are saying about the PWs. He cannot say when the disputed land was converted into periodic patta. He cannot say as for how much land the suit has been filed. The PW4, Brajendra Das, deposed that the Narayangao and Tinipukuri are adjacent villages. Defendants are members of the Horbodoya Shiva Mandir. Before formation of BTAD, the Tinipukuri village was under Pochim Borbhag Moja. He cannot say if Tinipukuri village is still under Pochim Borbhag Moja after creation of BTAD. The office of Horbodoya Shiva Mandir Narayangao is still in Tinipukuri. This is very important, Lordship. The Tinipukuri village is a Bhudan Gramdan village, whereas Narayangao is not a Gramdan village. He stated that Horbodoya Shiva Mandir functions under the Assam Horbodoya Shiva Mandal. It is found that all the three witnesses stated that BTAD is a separate Boro land. Now, Lordship, the fact that the Horbodoya Shiva Mandir was there from 1966 has been admitted by the PWs. Now the PWs do not know from when Narayangao Shiva Mandir has started. But they know that Horbodoya Shiva Mandir was existing since 1966. Now, this is very important, Lordship. The defendant, what defendants has adduced, Lordship. Now, Lordship may kindly note that the plaintiff has not even exhibited any document to prove their ownership of the land. The defendant adduced evidence of 6 witnesses. The defendant Maneshwar Brahma deposed as DW1 and stated that as per Assam Gramdan Act 1961, The then Deputy Commissioner P.H. Trivedi has declared villages Tinpukuri as Gramdan village with effect from 12 August 1963. And it was notified in the official gazette. The Brahma was the president of Tinipukuri Gramdam Sabha. He has exhibited the documents core is the notification of 12/8/1963 written in English. Exhibit Kho is the notification dated 15/8/1963 written in Assamese. Exhibit Go is the letter issued by the Office of Deputy Commissioner Kamrup to the then President late Lokhi Brahma of Tinipukuri Gramdan Sabha. The residents of Tinipukuri Gramdan village got inspired by the activities of Mahatma Gandhi and Acharya Vinoba Bhave, and under All India Horbodaya Committee and under Assam Horbodaya Kheba Mondal constituted the organization in the name and style of Horbodaya Kheba Mondir, authorized by Assam State Bhudan Gramdan Board, and registered it under the society's registration on December 1966. The registration number is so and so. The organization has its own memorandum of association. He submitted that the following documents are marked as Exhibit Ungo is a true copy of the certificate of registration of Horbodaya Kheba Mondir. Exhibit Prathamso is the original certificate of the registration of societies. Exhibit Dityoso is the memorandum of association. At the instance of Tinipukuri Gramdan village in the year 1971, Horbodaya Kheba Mondir obtained the land in the name of obtained the land in village Narayangau. Lordship, this is very important. Lordship, can you mark it? How we got the land? Under 111 annual Khiraj Patta. Exhibit Jaw is the annual Khiraj Patta issued in the name of Horbodaya Kheba Mandir dated 24/7/1971. Accordingly, in the name of Horbodaya Kheba Mondir, 25 bigha 1 kotha under dag number 1001 and 18 bighas under dag number 1002, total 43 bighas 1 kothas under annual patta was allotted. On application filed by the Horbodaya Kheba Mondir, that means us, the remaining land under Sorkari dag number 395 of Narayangau, measuring 18 bighas 2 kothas, was converted into KP patta number 176. Of dag number 1002 Ko by order dated 15/12/89 on payment of premium through treasury challans. Exhibit Jha is the certified copy of the Patta 146 and dag number 1001 dated 6/8/1990. Exhibit Neo is the certified copy of the Patta number 176 of dag number 1002 dated 6/8/1990. And Exhibit Modhoniato is the treasury chalan deposed by DW1. So we have, this land has been settled in our name after we paid our revenue. The DW1 has also exhibited the order passed in the case number 291/89, 52 of 10 and marked as Exhibit Modhonia Tho and Exhibit Modhonia No. The witness further stated that at the time of computerization of land record, they noticed that the word Narayangau was introduced in the Jamabandi of Patta number 146 and 176 after Horbodaya Kheba Mondir. Now this is how the plaintiff are claiming. Taking advantage of it, the plaintiff and some other person of Narayangau formed the Horbodaya Kheba Mondir, Narayangau, first time, in order to claim the disputed land. Exhibit TO is the computerized certified copy of Jamabandi of Patta number 146. Exhibit TO is the handwritten certified copy of the Jamabandi of Patta number 146. Exhibit DO is the computerized certified copy of the Jamabandi of Patta number 176. And Exhibit DO is the handwritten certified copy of the Jamabandi of Patta number 176. The defendant thereafter made an application on 15/7/2010 before the Deputy Commissioner Nolbari for correction of the word Narayangau inserted in the computerized Jamabandi of Patta number 146 and 176 after the word Horbodaya Kheba Mondir by replacing it with the word village Tinipukuri. The circle officer by order dated 2011 had made necessary correction of it. Exhibit PHO and Exhibit BO are the corrected certified copy of the computerized Jamabandi of Patta number 146 and 176 respectively. The witness has also exhibited the inland revenue payment receipt of KP Patta number 146 and 176. Exhibit Bho are the said revenue receipt. The other defendant witnesses also supported the evidence of PW1. The Lot Mondal, who deposed as DW6 during cross-examination, stated that the village Sinipukuri is under Baksa district. As per the order of the circle officer, the record shows that the Sarvodaya Hema Mandir, Pochim Borbhag, village Sinipukuri, but the disputed land is in Narayangao. He confirmed that the correction of the computerized copy of the Jawabandi of Patan number 146 and 176. TW2 during the cross-examination stated that Narayangao is not a Gramdan village. Since the plaintiff has claimed for declaration of right, title, and possession over the suit land, therefore, burden lies on the plaintiff to prove their title, possession, and right over the suit land. Lordship, this is very important. Lordship, may kindly mark this, Lordship. The plaintiff has to prove its own case. In the suit, it is found that the plaintiff in the plaint has claimed that the land described in Schedule Co of the plaint is a reserved land of Narayangao, and local people of the same village set up many institutions, including religious institutions, in the name of Sarvodaya Hema Mandir. Before the constitution of BPAD, the Tinipukuri village was under the district of Nalbari, and the head office of Narayangao Hema Mandir was at Tinipukuri village. The plaintiff has not produced any document regarding constitution of Sarvodaya Hema Mandir Narayangao or Narayangao Hema Mandir. The plaintiff has not proved the existence of Sarvodaya Hema Mandir Narayangao or Narayangao Hema Mandir by any documentary evidence. The plaintiff has not proved whether Sarvodaya Hema Mandir Narayangao or Narayangao Hema Mandir is a registered organization and when it was formed. The plaintiff has failed to furnish any documents to show that plaintiff's organization, Sarvodaya Hema Mandir Narayangao or Narayangao Hema Mandir, was allotted annual patta of the disputed land, and later annual patta was converted into a envelope patta on payment of premium by the plaintiff organization. The plaintiff has failed to prove that the plaintiff organization has paid premium for conversion of annual patta into periodic patta. On the other hand, the defendant has proven by documentary evidence about the existence of Sarvodaya Hema Mandir Tinipukuri by exhibit Ko, Kho, Go, Gho, Ungo, and Prathamsa. The defendant has also proved the issuance of annual Khiraj Patta number 111 in the name of exhibit Jo. The defendant has also proved the premium paying chalan for conversion of annual Khiraj Patta to periodic patta by exhibit Mudhoniyato. The premium was paid by the defendant Maneswar Brahma, president. The land record also proved the title of the defendant organization Sarvodaya Hema Mandir Tinipukuri over the disputed land. Regarding possession of the disputed land, already two cases were filed. One by Abdul Guni, which is numbered as Miss Case 291 of 89, and the other by the plaintiff, which is numbered as 52/10. In both the cases, executive magistrate and the additional district magistrate respectively declared the possession of the defendants over the suit land. Exhibit Pho and Bo also proves that the defendant organization's name has been mutated in respect of KP Pattern number 146 and 176. The defendant have also furnished the land revenue payment receipt of the disputed land. Therefore, it is much clear that the defendant organization Sarvodaya Hema Mandir Tinipukuri has got right, title, and possession over the suit land. Due to bifurcation of the district, the defendant organization cannot be barred from having land in another district. The learned court below was wrong in holding that the defendant organization Sarvodaya Hema Mandir Tinipukuri is now included in the BTAD area, and so they cannot have land in Narayangao. The learned court below was wrong in holding that the different organization cannot have disputed land situated in Narayangao, as it is not a Gramdan village. The learned court below mentioned of having gone through the documents submitted by the plaintiff, but I found that not a single document was submitted by plaintiff to prove the case. It is also found that the learned court below never discussed any documentary evidence submitted by the defendant to prove the claim over the disputed property. As such, I found that the decision of the learned court below holding the plaintiff organization having right, title, and interest and possession over the suit land needs to be interfered with. Therefore, I hold that the issue number 3 as negative and issue number 4 as positive. Now, only thing that during appeal it was stated that the report of Mondal and report of circle officer is there who says that there is a there is a Horbodaya Hema Mandir in Narayangao. And along with that, there are other institutions also. Now, nobody is denying that. But the thing is that Lot Mondal, neither the Lot Mondal nor the circle officer has stated that the plaintiffs are in possession of these lands.
Okay.
This is the only submission which I have with regard to the substantial question number 1.
As regards number 2.
No,
So according to you, there is no perversity.
no perversity, Lordship.
Yes.
Now, with regard to issue number 2, Lordship had a query. Now, Lordship, if I may just read the issue number 1. Issue number 1, whether the suit is maintainable. That has been that was with regard to this issue, the substantial question of law number 2 was framed.
Yes.
The plaintiff has filed a suit in representative capacity as president of Narayangao Unnayan Committee, whereas the plaintiff has claimed right.
Which page you are reading?
Page number 21 of the appellate court judgment.
Yes.
The plaintiff has filed a suit in representative capacity as president of Narayangao Unnayan Committee, whereas the plaintiff has claimed right over the suit land on behalf of Horbodaya Hema Mandir Narayangao. It is mentioned in the plaint that the plaintiff is a member of Horbodaya Hema Mandir Narayangao, but he did not submit any document to prove that he obtained any authority from the organization Horbodaya Hema Mandir Narayangao for filing the suit on their behalf. Neither the plaintiff has furnished any document to prove that he is the president of Narayangao Unnayan Committee, nor the plaintiff has filed any letter from the Narayangao Unnayan Committee authorizing him to file the suit on his behalf. The plaintiff also failed to prove that he is a member of the defendants organization Horbodaya Hema Mandir Tinipukhuri. The plaintiff also did not obtain any permission from the court to file the suit in representative capacity as required under Order 1 ruling. As such, I found that this suit is not maintainable. Now, this has been put to question before the appeal. According to the appellant, they have not filed the suit in their representative capacity. They have filed this suit as president of Narayangao Hema Committee. Now, Lordship, this fact may not be very correct. Why, Lordship, I'm saying, Lordship, may kindly take up the plaint.
Page.
Lordship, the plaint, Lordship would find in page number 52.
Yes.
The 52, Muhammad Abdul Qadir, son of Sarihatullah Sarkar, President Narayangao Unnayan Committee. He has stated that he is president of Narayangao Unnayan Committee. This has also been stated in para number 2. Para number 1. The plaintiff is the president of Narayangao Unnayan Committee and has instituted this suit in his capacity as president of the committee. The plaintiff has no personal interest in the suit. This is his statement made. Now, Lordship may come to the prayer portion, Lordship. In the prayer, he says, exhibit the prayer number Kha. For permanent in prayer number K, for the declaration of right, title, and interest over the land described in Schedule Kha in favor of Narayangao Horbodaya Hema Mandir under Pochim Borbhag Moja of Nolbari district, which is managed by the committee of the plaintiff. Now he has sought for a declaration not on his own, but of a property allegedly belonging to the committee, not his own personal land. So under no circumstances, the appellant can come and say that this suit has been filed in individual capacity. Now this further proves from the appeal itself. Now Lordship may kindly see the appeal, the cause title. Cause title says, cause title of the appeal, present appeal, Lordship.
Yes.
On the death of Abdul Kadir, the president of Narayangao Unnayan Committee, Muhammad Hilal Ali, the secretary in charge of Narayangao Unnayan Committee, son of so and so. Now, if he would have filed this case under individual capacity, he would have made his legal heir the party. But instead, he has been succeeded by the secretary of the Unnayan Committee. That means he has never filed this case as a
No,
individual
the
capacity.
relief was sought.
No, relief was not sought.
No, relief of declaration of right, title and interest was sought in favor of whom?
In favor of the committee?
Whether committee had any legal, is a
No.
legal entity?
No.
Whether it can have title over land?
No. Now, Lordship, that for suppose assuming the land, they have a legal entity also. Assuming if that be so, even then, without taking recourse to order 1 rule 8, they cannot proceed further.
Okay.
That is my submission, Lordship. Now, the only way a president of any society may be registered, or even worse, may not be registered, he has to take recourse to order 1 rule 8. Without that, he cannot file the case in his capacity. Lordship, I'm just giving a judgment in that regard, because that was the query in the last.
And if a suit is filed in representative capacity, then leave for filing that suit has to be taken.
Has to be taken, Lordship.
And that was not taken.
Lordship, my humble submission is that he cannot file a suit without representative capacity. He has to take recourse to order 1 rule 8. A person cannot file a case against seeking relief against a committee, in favor of a committee. He may be president or then what? Huh? Itu lesser cerita dia lah. Satu dua. Almost in a similar context, Lordship.
Where?
The last portion, Lordship. This is in this case, Lordship.
Paragraph number?
Paragraph number 3, Lordship.
3. Yes.
Under such circumstances, the question is to be considered is whether only one member of the society, whether he be the president or secretary of something more than both, can maintain a suit on behalf of the society. In my opinion, he cannot. The money was not advanced by him. This is the facts, some facts which is different. The committee is a mere association of some gentlemen for a specific purpose. The improvement of a high school referred to above, whatever the improvement of that they hope to effect, the money belongs to all members of the committee and not to the president. He is not therefore entitled to the money exclusively. He has not been given a power of attorney by the members to institute the suit on behalf or on their behalf. Therefore, the suit by the president of the unregistered society, this is also an unregistered society, Lordship, is not maintainable without power of attorney being given by all members of the committee, empowering him to institute the suit. Therefore, the judgment of the learned subordinate court so and so are set aside, and a civil revision petition is allowed. Now, Lordship, he cannot do that, Lordship. Now, further substantiating it, Lordship, in the case of in the case of Ilaichi Devi, the division bench of the Honorable Apex Court, Lordship,
Para,
and number 31, Lordship. A bare perusal thereof would show that a society registered under the Societies Act as contradistinguished from a company registered by the name of president, chairman, or principal secretary or trustee, as shall be determined by the rules and regulations of the society, or in the name of such person as appointed by the governing body of the for the occasion in default of such determination. Therefore, it is not correct to contend that the capacity of suing or be sued in its own name. Now, Lordship, a precedent, what this judgment, Lordship, the appellant has sued me in my individual capacity. They have sought for a declaration against the land of the society, and my society is a registered society. Now they cannot sue me in my individual capacity as they have done, Lordship.
without making the registered society a party.
Yes, Lordship. The Lordship may kindly revert back to the plaintiff, Lordship. In the plaintiff, Lordship, they have made 4 parties: Moneshwar Brahma, Probin Brahma, Bolen Boro, and Bhavan Brahma. All these are individual person. They have not made the registered society a party. And all the PWs has stated that it is a registered society and it has been existent since 1966. If that be so, they have not made any of the Samiti a party. So this is also this suit also goes for non-gender of parties, Lordship. Now going ahead, Lordship. তুমি কলকাতার রাজনীতি দিয়েছো। Lordship, this is a judgment of the Kolkata High Court. In this judgment, all the points regarding Order 1, Rule 8 has been discussed thoroughly, Lordship.
Which you are relying?
Lordship, I have relied in 3 judgments, which is already cited in this judgment only. Lordship,
Which para you are relying?
Lordship, I'll come to the last para, what the court has held, Lordship. How Order 1, Rule 8 has to be filed, Lordship. Last para, para number 24.
Yes.
On the other hand, the judgments cited on behalf of the opposite party are apt in the present context. All the judgments indicate that the provisions of Order 1, Rule 8 of the Code are intended to avoid multiplicity of litigation and ought to be given a liberal construction. The best way for an unregistered society to maintain a suit, in fact, as indicated in such judgment, would be for the secretary or its office bearers to sue in a representative capacity on behalf of the society upon seeking permission under Order 1, Rule 8 of the Code. That is what was done precisely in the present case. That is, so it has been held the only way that a unregistered society can file or sue or be sued or maybe sue is by taking recourse to order one rule 8. There is no other way they can do it.
Okay.
And because, and if your lordship would see the issue number 1, which is decided by the appellate court, the appellate court has exactly said the same thing. Because order 1, the last portion, lordship, may kindly see the last portion in page number 21.
Yes.
Page number 21 of the appeal.
Yes, order one rule 8 was not followed.
Yes.
No permission.
No
was sought.
permission was taken.
Okay.
That is my humble.
Yes, Mr. Sharma. Any reply?
In arguing the case, order, my learned friend has forgotten the basic principle of the pleadings, my lord. What are the, your lordship will see to what are the pleadings of the party? In the lower court, they have submitted written statement against our pleading. They have nowhere stated that the plaintiff has no right to sue and it was not the, no permission was obtained, all these things. So the learned first civil judge, he has rightly decided the issue. Page 39, issue number is para 12, issue number is issue number 1, para 12, page 39. The defendant have stated in their written statement that the suit is not maintainable. Only that point. Suit is not maintainable. Why it is not maintainable? They are state specifically in the pleadings. So the civil court cannot go beyond the pleadings, my lord. What are the pleadings in the plain and the written statement? And out of that, issue is framed and it should be decided accordingly. So the nowhere stated that suit is not maintainable because such reasons, my lord. So, however, they have failed to show as to in what manner this suit is not maintainable. It is specific, my lord. The plaintiff has filed this suit representing the public of Narayangao for declaration of the right title and interest. The defendants have defended the case, stating that they are managing the affairs of the Sarvodaya Mandir at Narayangao. Hence, in my opinion, suit is maintainable, my lord. So it should be specifically pleaded in the written statement that because of Sasan, she is not the, it is not registered or nor he has any right capacity to sue on behalf of the society. Nothing has been stated. That is why that has been rightly decided by the learned civil judge, junior division in favor of the plaintiff, my lord. So in the appellate court also, in the memo of appeal, that is also not specifically pleaded. That for not obtaining permission under order 1 rule 8 of the CPC, the suit is not maintainable in the capacity. That should be specifically stated. So nothing, no pleadings to the civil court cannot go beyond the pleadings. What is stated in the pleadings and suit is to be decided accordingly. So in that is my suit is not the representative suit, my lord. My suit is a declaratory suit. It is declaratory suit under the provision of section 34 of the Specific Relief Act, seeking declaration. In case of representative suit, the
Declaration.
My lord,
Declaration for whom?
declaration for the Seva Mandir, my lord, is the
Whether Seva Mandir is a legal entity.
Seva Mandir is the legal entity, my lord, because it is formed and registered. Promotional ceremony, it is a registered matter, registered society. So the plaintiff has right to sue. The section 6 of the registration act. Registration act, that is it is registered, so the either president or secretary can sue. No permission under order 1 rule 8 CPC is required, my lord. So in the memorandum, my lord.
Miscellaneous, the memorandum of understanding, the institution shall sue or be sued through its president, chairman, secretary.
Yes, no, whether the organization of which you are claiming to be president was a registered society.
No, yes, on behalf of the society, on behalf of the society.
No, whether your society was a registered society.
Then your lordship will have to see the status of the land. What the circle officer and the, because they are the custodian of the land records. Circle officer or a mandal, they are the
No,
custodians
no,
of the land
you
records.
first answer to my query. Whether your society was a registered society.
Registered society.
Where is the document?
Corporate ceremony.
No, which document? You just tell me.
Corporate ceremony.
You exhibited that document.
No, no, that is filed in a lower court record. No, it is lower court record.
No, you need not to show it to me. You can.
This is ours, this is not there.
Corporate ceremony is not.
This they have exhibited.
That is our exhibit, lordship. We have exhibited.
Yes.
But the corporate ceremony is there. You may give it. So the lands belong to the ceremony. It is stated by the cycle officer report and lot mandal matter. So land is our, and I have right to sue. I have right to sue. Why I cannot right to sue? That is not in the pleadings, my lord. My humble submission that the civil court cannot go beyond the pleadings.
Okay.
Now those things has been agitated here that because of non-nation, because of not permission, under nothing has been pleaded in the lower court, my lord. First, it should be in the WS, my lord. Written statement they must specifically plead it. But that is why the learned Munship has rightly stated that it is not mentioned why the suit is not maintainable. Hence, the suit is this issue is decided in favor of the plaintiff, my lord. So if those who are not pleaded, not in the record, not on the record, the first time it cannot be raised before the Honorable High Court in civil affairs, that is the second appeal, my lord.
Okay.
The second appeal that is there on the substantial question of law, that is only point of maintainability is the point of law that has been raised under order and rule 8. But my submission that order and rule 8 is not applicable in this case. It is not the representative suit, it is a declaratory suit, my lord.
Okay.
So regarding the possession, the cycle officer and the mandal has specifically stated their report cannot be ignored. Official and non-official witness, your lordship may discard it. But what official witness has stated, who are the custodian of the land record, what they have stated, they are to be believed, my lord, taken into consideration. So what the cycle officer has stated, the page 44, para 23, DW6 is that the mandal of Gauhati Revenue Circle, he stated that the suit land covered by pota number so-and-so, dag number so-and-so, and the Sorbudoi Sawa Mandir Paschim Parbhag Moja is mentioned as potadar of the suit land. The Sawa Mandir is the holder of the land, my lord. During the cross-examination, he stated that the suit land is in Narayangao, and hence, and there is a Sorbudoi Sawa Mandir at Narayangao. Tinpukuri is the Gamdani place where this Narayangao is. So this witness has been stated from the record. That is not his verbal person, my lord. What is para 24, during the course of a commission was also issued for local inspections of the suit land. This circle officer Gauhati Revenue Circle was appointed as a commissioner to determine the possessions of the parties. The report of the commission suggested that the suit land is situated within the place Narayangao of Paschim Parbhag Moja under Gauhati Revenue Circle. The public institutions such as Sorbudoi Sawa Mandir, Sawa Mandir 17 number, Alia Gaon Panchayat, Tinpukuri, Acharya Vidyapit, ME School, Angadabadi Center Sorbudoi Jatiyo Vidyalaya, Acharya Binoda High School, during Durga Mandir and Narayangao Chowk Bazar are found to be situated in the Narayangao, and being public institutions are managed and looked after by the people of the Narayangao, my lord. So this circle officer report cannot be discarded, my lord. He, after field verification, what he has found, actual picture he has depicted in the report, my lord. And this Narayangao. Narayangao, Normati, Boralkusi, and the Tinpukuri place together. The Narayangao is not situated over Gamdan place. That is specific, my lord, not in the Gamdan place. The Tinpukuri place was under the administrative jurisdictions of the Gauhati Revenue Circle. Gauhati Revenue Circle till December 2013, but the representations, but the reorganizations of circle, it was excluded from Gauhati Revenue Circle and is included in BTAD. I have gone through the pleadings and evidence put forward by both the parties. I have also perused the exhibits of both the parties and the report of the commissioner. Upon carefully going through the submissions of the both the parties and also the revenue circle or evidence available on record, it appears to me that the Tinpukuri Bhutan Gramdan blaze was constituted in the year 1961. The Sorbodoi Savamandir Tinpukuri was established and registered under the Society's Registration Act 1860 and Assam Sorbodoi Seva Mandir, which was managed by the Assam Bhutan Gamdan Board with the inspirations of the Mahatma Gandhi and Acharya Vinoba Bhave. The Sorbodoi Seva Mandir is situated upon 43 because 1 quarter of land of the Narayangao, which is specific where we sought for declaration of place. Paschim Borbhag Moja till the constitution of BTAD, the local people of Narayangao and Tinpukuri were managing the public institution, including the Sorbodoi Seva Mandir. After bifurcations of the Tinpukuri, place was included in the BTAD, whereas the Narayangao remained in Nalbari district. The people of Narayangao has been managing the affairs of the public institution, including Sorbodoi Seva Mandir, which is specific. Sorbodoi Seva Mandir, till the that which is revealed from the people of report of the commissioner. And the Suitland including Sorbodoi Seva Mandir is situated over in Narayangao, which is not a Gamdani place. The Sorbodoi Seva Mandir, which is established under the Gamdan board, has to be situated upon the Gamdan place as it is to
This
be.
you have already read.
Yes.
earlier.
That is why so commissioner report, Monroe report is clear that the land belongs to the Narayangao and they are the managing it. So these two witnesses cannot be discarded, my lord.
Okay.
They are the disinterested and official witness, my lord. So the whole finding is based on the evidence of these two witnesses. My lord, therefore, you also kindly see the written statement filed by the defendants. It is very lengthy one, page 67.
No, what you want to point out? You are only replying, you have already made your submission.
I have replied that the order 1 rule date is not applicable here.
Okay,
It is the declaratory issue and the maintainability point was not raised in the written statement. For what reason it is not?
That you have submitted.
That pleading should be specific, my lord. Civil court cannot go beyond the pleadings, my lord. That point has been agitated in the before your lordship now. In the trial court did not exhibit. Even in the first appellate court, that point was not specifically raised for such and such as should be not maintainable. So a new thing cannot be brought before the second appellate court, my lord. So my humble assumption that I have ample merit in my appeal, my lord, then may kindly be allowed by setting aside the finding recorded by the learned first appellate court.
Heard Mr. K. Sharma, learned counsel for the appellant. Also heard Mr. M.K. Deka.
P. Decker.
Sorry, P. Deka, learned counsel for the respondents. This regular second appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellant, namely, was initially filed by the appellant, namely, has been filed by Muhammad Hilal Ali, who is the secretary in charge of Narayangaon Unnayan Samiti, on death of the original plaintiff, namely Abdul Qadir, impugning the judgment and decree passed by the Court of Judgment and decree dated 23/3/2017, passed by the Court of London, civil judge, passed by the Court of London, civil judge Nalbari, in title appeal number 6/2016, whereby the judgment and decree dated 28/3/2016, passed by the Court of London, Munsif number 1 Nalbari, in the title suit number 50/2010, was reversed, was set aside, and was reversed, and thereby allowing the title appeal filed by the.
I will be excused, if I'm not required, my juniority.
Yes, yes, yes. File, ये लिख ले, filed by the present respondents. The facts relevant for consideration of the instant regular second appeal, in brief, are that the predecessor in interest of the present appellant, namely namely Abdul Qadir, had filed a suit, filed a title suit, filed a title suit before the Court of Learned Munsif number 1 Nalbari against the present respondents. The said suit was registered as title suit number 50/2010. It was pleaded in the plaint of the said suit by the plaintiff that he was the chairman of Narayangaon Unnayan Samiti, and stop. It was also pleaded therein that the land described in Schedule K and Schedule K of the plaint was converted into periodic patta bearing number 146 and dag number 1001, covering 21 bigha, 3 katha, 10 lechas of land, and another plot of land measuring 14 bighas 2 kathas 36 14 bighas 2 kathas of land in periodic patta number 176 covered by dag number 1002 was mutated in the name of Sarvodaya Seva Mandir, Narayangam. The aforesaid suit was filed by the predecessor in interest of the present appellant, seeking relief of declaration. Where is the prayer portion of the suit? Which page?
My lord, page number 55.
Relief of declaration of right title and interest of the land described in Schedule K. K will be within inverted comma. Schedule K of the land. Schedule K of the plaint in favor of Narayangam Sarvodaya Seva Mandir. And also for permanent injunction restraining the defendants from interfering in any manner within the aforesaid land. It was pleaded in the plaint that as the Narayanpur Sarvodaya Mandir, Narayangam Sarvodaya Seva Mandir was earlier instituted in village Tinipukuri. The defendant had started interfering with the possession of the plaintiffs and claiming the institution of Narayangam and making a claim over the Narayangam Sarvodaya Seva Mandir. It was also pleaded in the plaint that after bifurcation of the districts of Baksa from Nalbari district, the village Narayangam fell in Nalbari district, whereas Tinipukri falls within Baksa district. Stop. The defendant's next para. The defendant contested the suit by filing written statement, taking various defenses like lack of cause of action as well as non-maintainability of the suit. It was also pleaded in the written statement that the contentions of the plaintiff in their plaint are false and baseless. It was also pleaded in the written statement that the suit land has been mutated in the name of Sarvodaya Seva Mandir. However, due to a misprinting, the name of Narayangam was inserted in the revenue records at the initial stage. However, later on, the said error was rectified and the records of and the revenue records were corrected by deleting the name of Narayangam from therefrom. It was also pleaded in the written statement that the suit land was under the occupation of Sarvodaya Seva Mandir, Tinipukuri since the year 1963 and the Sarvodaya Seva Mandir, Tinipukuri was established and registered under Societies Registration Act 1860 and was managed by the Assam Bhudan Gramdan Board. Stop. Upon pleadings of the parties, the trial court framed following issues. Court issues A from page number 38 of the memo of appeal. Stop. In support of their contention, in support of the contention raised in the plaintiff examined 4 witnesses and however, no documentary evidence was adduced by the plaintiff, whereas the defendant side examined
3 witnesses also.
3 witnesses.
PW 1, 2, and 4. 3 is absent.
3 witnesses. However, the defendant side, no, however, Kalika, examined 6 witnesses and exhibited how many documents? Exhibited several documents in support of their contention.
20 documents. 20. 20 exhibits.
Within bracket 20 exhibits. Stop. Ultimately, after considering the materials on record, the trial court, within bracket Court of Learned Munsif number 1 Nalbari, by judgment dated 28 March 2016, passed in title suit number 50/2010 decreed the suit in favor of the plaintiff. Next paragraph. Being aggrieved by the aforesaid judgment, the present respondent preferred an appeal before the Court of Learned, Civil Judge Nalbari. The said appeal was registered as title appeal number 6/2016. By the Six oblique 2016. Stop. Thereafter, continue Rakibo. Thereafter, by the judgment dated 23/3/2017, the First Appellate Court allowed the appeal and set aside the judgment of the trial court and reversed its finding by dismissing the suit. The aforesaid judgment of the First Appellate Court has been impugned by the appellant in this regular second appeal. Stop. This regular second appeal was admitted by this court on 22/12/2017. Stop. While admitting the appeal, this court formulated following substantial questions of law. Number one, whether the First Appellate Court is correct in holding that the appellant/plaintiff has no right, title, interest and possession over the suit land described in Schedule K of the plain. Number two, whether the learned First Appellate Court is correct in holding that suit is not maintainable while deciding issue number one in view of the provision or orders in view of provision of Order 1 Rule 8 of the CPC. Number three, whether the impugned judgment passed by the First Appellate Court suffers from perversity and infirmity. Stop. Next paragraph. Mr. K. Sharma, learned counsel for the appellant, has submitted that the First Appellate Court had heard and committed perversity in ignoring the evidence which was on record in arriving at a finding that the plaintiff's organization does not have any right, title, and interest and possession over the Schedule K land. Stop. He submits that whereas the trial court was right in relying on the oral evidence of the Lat Mandal was PW?
Official witness, it was not figure. No, they have only submitted a report.
Commission report.
Commission report.
Right in relying on the report of, no, or not oral evidence. Right on, right in relying on the evidence, relying on the report of the commission, which was issued by the trial court during the trial, wherein, stop, he submits that the report of the commissioner and the commission report was submitted by the circle officer. Circle officer, Gograpa Revenue Circle, who has categorically stated in his report that the suit land was situated in village Narangaon of Paschim Borbhag Moja under Gograpa Revenue Circle. He further submits that the trial court was also correct in relying on the aforesaid report, wherein it was categorically mentioned that that public institutions like Sarvodaya Seva Mandir situated in Narangaon, where was managed and looked after by the people of Narangaon.
No, Lordship, would see page number 44.
No, there are other villages also.
Yes.
But I am reflecting his submission only. I have noticed the other names of other villages. So he submits that the first appellate court committed perversity in ignoring the aforesaid commission report, aforementioned commission report, and thereafter arriving at a conclusion that the appellant has failed to prove its right title and interest over the suit land. Stop. Next paragraph. Learned counsel for the appellant also submits that the first appellate court also committed perversity in holding that the suit filed by the plaintiff was a representative suit, and therefore compliance of the mandate of Order 1 Rule 8 of the Code of Civil Procedure 1908 was necessary. he submits that the Sarvodaya Seva Mandir is no, he submits that the present appellant is the president of Narayan-Gaon Unnayan Samiti, situated at Narayan-Gaon. And as such, he has filed the suit, and as such, his predecessor Abdul Qadir had filed the suit in his capacity as president of Narayan-Gaon Unnayan Samiti, and therefore it is not a representative suit. He also submits that the appellate court also erred in not considering the fact that while raising the question of maintainability in the written statement, the present respondents have not specifically stated as to on what ground the objection as regards maintainability was raised. He submits that in their written statement, it was nowhere stated by the present respondents that the suit is barred by Order 1, Rule 8, Clause 2, within bracket 2 of the Code of Civil Procedure for want of taking leave to file the suit in representative capacity. He submits that in a civil suit, the parties cannot go beyond pleading, and same is applicable to the adjudicating court also. He submits that the First Appellate Court erred in deciding the question of maintainability on a point which was never agitated by the respondents in their written statement. Stop. On the other hand, Mr. M. Deka,
P. Dekar.
sorry, Mr. P. Deka, learned counsel for respondent, has submitted that the First Appellate Court has correctly decided the appeal after considering the materials available on record and the impugn judgment and decree does not warrant any interference by this court at the stage of second appeal. He submits that there is no perversity on the part of the First Appellate Court in passing the impugn judgment and decree, as it arrived at its conclusion on the basis of evidence on record. He submits that the trial court had erred in concluding that merely because of the fact that Sarvodaya Seva Mandir was Sarvodaya Seva Mandir is situated in Narayangao, the Sarvodaya Seva Mandir, Tini Pukhuri does not have any right, title and interest over the same. He submits that merely because after bifurcation of the district of Baksa and Nalbari, the Tini Pukhuri village fell within the jurisdiction of Baksa village. What is the name of your society? Registered society. The
Sarvodaya Seva Mandir, Tini Pukhuri.
The Horbode Heva Mandir Tini Pukhuri, which is a registered society, cannot possess land in another village, that is Narayangao. He submits that the reasoning of the trial court that as the Sarvodaya Seva Mandir is situated in Paschim Bhag Moja, in Narayangao under Paschim Bhag Moja, which is not a Gramdan village, the defendants who are resident of Tinipukhuri village may not have any authority over institutions situated in Narayangao village. He submits that this reasoning of the trial court was fallacious reasoning, which was ultimately rectified in the impugned judgment by the First Appellate Court on the basis of documentary as well as oral evidence on record. He further submits that the trial court, while decreeing the suit in favor of the present appellant, has also erroneously observed in its judgment that the plaintiff has adduced oral and documentary evidence. However, no document was ever exhibited by the plaintiff in the trial, and said fact has been reflected by the First Appellate Court in the impugned judgment, has been correctly reflected by the First Appellate Court in the impugned judgment. The learned counsel for the respondent further submits that the report of the report of the commission report of the circle officer of Gograpa Revenue Circle, which was relied upon by the trial court, never stated that the Narayan Seva Mandir is in possession of the plaintiff's organization. though the commission was issued only to ascertain the position. It has only stated that the Narayan Seva Mandir was situated in Narayangaon, a fact which the present respondents are also not denying. He further submits that even the report of the commissioner mentioned that the public institutions, including the Sarvodaya Seva Mandir, was looked after and managed by the people of Narayangaon, Namati, Baralkusi, and Tinipukhuri village together. And it was not Tinipukhuri village together, from which it cannot be inferred that the suit land was in exclusive possession of the plaintiff's organization. He submits that the plaintiffs have miserably failed to adduce evidence to show that the Narayans, to show their right title and interest as well as possession over the schedule, over the suit land. Whereas the respondents has had, by exhibiting the documents like registration certificate of the
Pattas, even Khiraz Miadi Patta,
documents like Khiraj Miadi Patta, registration certificate,
premium payment receipt.
Premium payment receipt, and
other document like the copy of the orders passed by the
and mutation orders have clearly shown that the Sarvodaya Seva Mandir Tinipukhuri is having the title and possession over the suit land. He submits that hence the finding arrived at by the first appellate court cannot be regarded as a perverse finding. He also submits that the first appellate court was correct in holding that the suit filed by the present appellant before the trial court was not maintainable, as no permission was obtained under Order 1, Rule 8 within bracket 2 of the Code of Civil Procedure 1908, as was required in case of a representative suit. He submits that a bare perusal of the cause title of the plaint as well as this memo of appeal would indicate that the organization which the appellant is claiming to be the president, that is Narayangam Unnayan Samiti, is not a registered organization. And he is claiming, and the appellant has claimed himself to be the president of said organization. He submits that whenever a secretary or president or any other office bearer of a unregistered society intends to sue someone, he has to sue in a representative capacity on the basis of representative capacity on behalf of the said organization. And for suing so, prior permission of the court under Order 1, Rule 8 of the Code of Civil Procedure is to be taken, which the present appellant failed to take, and the first appellate court correctly decided that the suit is barred by the provision of Order 1, Rule 8 within bracket 2 of CPC. In support of his submission, learned counsel for the respondent has cited following rulings. Shri Biraj Bhattacharya versus Indian Culture Center and others. Reported in 2018 0 Supreme within bracket Calcutta 474 within bracket para 24. Number 2, Chehat and others versus Ilaichi Devi within bracket dead by LR and others versus Jain Society Protection of Orphan India and others, reported in 2003 8 SCC 413. Para 31. Number 3, S. Nesamuni Nadar versus Nidalam Government High School, reported in 1978 0 Supreme within bracket 1 MAD 197. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. I am reserving the judgment. Reserving it. Not so and so. Judgment reserved. Itu ঘুরাই দিও।
Hello.
May it please your lordship. Lordship, the engaged counsel for the respondent number 2 is out of station. The Lordship may please to pass over the matter for days.
So you are not ready.
Not ready. And also I'm not the engaged counsel here. A Ganguly. I'm on behalf of A Ganguly here.
Okay. Yes. Mr. Sharma. Anything?
No objection.
Heard Mr. UB Sharma,
You be sure.
learned counsel for the appellant. Also heard Mr. What is your name?
G Das Lordship.
G.
G Das Lordship.
G. Das,
Behalf of A Ganguly.
appearing on behalf of Mr. A. Ganguly, who submits that, who prays for an adjournment on the ground that engaged counsel for respondent number 2 is out of station. Also heard Mr. U. Datta,
I'm for one.
learned counsel for the respondent. Number 1, the prayer is not opposed to by the other councils, hence same is allowed. Let this matter be listed on 2nd of June.
Item 9.
June.
Obligation.
9 to hoy.
Matter may be taken at 2.
Okay, 2.
It's already 1. It can be taken at 2.
We'll take it up to 2.
Item 10.
You are ready?
Yes, Lordship.
You are also ready?
Yes.
Or else, Lordship, after the break, Lordship can take no if
No,
Lordship is tired.
no, I'm not tired. If it starts now,
Yes, sir.
then you can continue after at 2.
Yes, yes.
If we don't start, then we'll take up other matters and you have to wait till completion of that.
Done.
At least you can start.
Basically, our appeal, I'll read the judgment, but before that, basically our appeal is on the fact that the deceased himself was driving the vehicle, so he steps into the shoes of the owner of the vehicle as per Ningamma, and then the liability will be only based on that amount. Our High Court judgments are also there.
Any apex court ruling is there in
Yes, Ningamma Lordship.
that suppose deceased is
That is not applicable in this case.
okay. No, I'm just asking before she starts.
Sure.
Deceased is having valid license.
No.
Assuming I'm giving a situation.
No, here we are not on license. Lordship is thinking that like my other cases, this is
No,
also.
no, no.
Oh, acha.
He is having valid license.
Hmm.
He is lawfully driving the vehicle of somebody else. Accident occurred. Can he not be regarded as third party?
No, that is what is Ningamma judgment and our High Court. That is the issue here in this case.
Or he will not get any compensation?
No, he will be getting as per the policy, Lordship. Because if he steps into the shoes of the owner of the vehicle and here it was a motorcycle, he will be getting 1 lakh rupees.
The insurance cover which is for the owner of the vehicle.
Yes, owner and driver. The policy is here, Lordship, because policy no one denied.
What is the logic for this?
Lordship, because Lordship, owner is the first party. Insurance is the second party in
Yes.
a contract.
And a stranger is the third party.
As per MBA Act, Lordship, no, stranger, that is what Ningamma
Yes.
says. Lordship, the driver.
Okay, you start, otherwise next case will come at 2, unless you start.
No, I'll start, Lordship. That is what. I was just replying to Lordship.
Yes.
Lordship, the judgment starts on page 5, Lordship, of my memo of appeal, Lordship.
Page
5. Annexure 1.
Yes.
This claim case arose out of a petition under section 163A of the Motor Vehicle Act, MV Act in short, filed by the claimants claiming compensation of rupees 10 lakhs from the OP on account of death of the deceased Mainul Ali in a motor vehicle accident. Case of the claimants in brief is that on 6/2/2011, the deceased, namely Mainul Ali, was proceeding from Tamulpur side towards Bahbari by riding the motorcycle bearing engine number so-and-so, chassis number so-and-so. And on his way, when he reached at Kumarikata, all of a sudden the said motorcycle met with an accident due to its mechanical defect, as a result of which the deceased sustained grievous injury on his person. After the accident, the injured was admitted in the downtown hospital Gauhati for his treatment, and during the course of treatment, this injured succumbed to his injuries. The accident occurred on Rongya, Bhutan under the Tamulpur PS, and on being informed, the OC of Tamulpur PS registered the case as Rangya PS GD entry number 177 dated 13/2/2011. It is further mentioned in the claim petition that the deceased was a businessman by profession and his monthly income was 3,000. During course of investigation, dead body of the deceased was sent for conducting postmortem examination, and accordingly, postmortem was done on the dead body of the deceased, hence this case. On receipt of the notices, the opposite party number 1 entered their appearance and filed their WS in order to contest the case. OP number 1 stated that the claim petition is not maintainable in its present form, and that there is no cause of action made out in the claim petition, and that the claim of the claimant is highly speculative. They denied the age, occupation, and monthly income of the deceased. Besides denying the age, occupation, and monthly income of the deceased, as well as facts of alleged accident and the rash and negligent driving of the driver of the offending vehicle, the answering opposite party put the claimant to make strictest proof of the case by producing satisfactory documentary evidence: the police report regarding the alleged accident, the original insurance policy, fitness certificate, registration certificate, effective driving license, road permit, age certificate, income certificate, and medical examination report of the claimant, etc. And submits that the claimant have to prove that the vehicle in question was applied in conformity with terms and conditions of the insurance policy and the provisions of the MV Act, and thus rule framed thereunder. On the pleading of the parties, following issues are
We
framed.
will continue at 2.
Yes, sir.
At 2.
Okay, only one request. Nigama judgment, I have not here. Can I request? Give me that.
Yes, during the
So
lunch.
recess time.
Yes, Mr. Kolita.
Lordship, I'm sorry, my lord, for making mention at this hour, my lord. Lordship, item number 21, my lord. I'm appearing with the respondent, my lord, 3, and the appellant is also there, my lord. Lordship, we may prefer an adjournment. Matter may be fixed on 23rd of April, my lord, 23rd.
April may be difficult. It will go in the May or June.
My lord, any date in the first week of May?
Yes.
Heard Mr. What is your name?
Dr. Razal.
Heard Dr. R. Hawk, learned counsel for the appellant. Also heard Mr. T. Kolita, learned counsel for the respondent. A joint prayer, is it a joint prayer? Who is praying
In
for?
fact, it was my prayer, my lord.
Learned counsel for the respondent has prayed for an adjournment on the ground of personal difficulty, to which the learned counsel for the appellant does not raise any objection. Hence, the prayer is allowed. Let this matter be listed. 4th of June.
4th of
June.
No, Lordship.
Lordship,
Kindly
can
May.
it be in May, my lord?
In the month
If
of May.
possible, or May.
No, it may not be possible.
June is full.
Otherwise, you have to wait. Again, a date will come. 4th, let it be 4th of June.
One, yes.
Can you look at pencil? Hatta pencil ni.
Oh, apne submit ko pencil.
Ne itu try paro na.
Issue.
Issue page 7.
Issues.
Yes, page 7. Issues. Whether
Yes.
the victim Mainul Ali died as a result of injuries sustained by him in the alleged road accident dated 6/2/11 involving vehicle number, engine number so-and-so, chassis number so-and-so, and whether the said accident took place due to use and involvement of the said vehicle. Whether the claimants are entitled to receive any compensation and if yes, to what extent, and by whom amongst the opposite parties the said compensation amount will be payable. During course of trial, the claimant side has examined one witness by filing evidence on affidavit and contesting opposite party insurance company who has duly cross-examined the claimant witness. The contesting opposite party insurance company has not adduced any defense evidence. I have heard argument from both the sides orally and written and carefully gone through the evidence on record. My finding in respect of the above noted issues in review of the evidence on record and in the light of the submission of learned counsel from both sides, from both the sides are as follows. Issue number 1. The claimant CW1 has averred in the claim petition and also stated in her evidence that on 6/2/2011, her deceased husband, namely Mainul Ali, was proceeding from Tamulpur side towards Bahbari by riding the motorcycle bearing engine number so-and-so, chassis number so-and-so. And on his way, when he reached at Kumari Kata, all of a sudden the said motorcycle met with an accident due to its mechanical defect, as a result of which the deceased sustained grievous injury on his person. After the accident, the injured was admitted in the downtown hospital Gauhati for his treatment, and during the course of treatment, the injured succumbed to his injury. The accident occurred under the Tamulpur PS on Rangia Bhutan Road. She further stated that the deceased was a businessman by profession and his monthly income was rupees 3,000. In support of her evidence, and she has submitted the accident information report post-mortem examination. Now, let us go to decide whether the accident took place due to use of the vehicle number so-and-so, chassis number so-and-so, or not. From the evidence of CW1 and other documents submitted in this case, it is clear that the deceased died due to the injury sustained in the motor vehicle accident. As per accident information report, which was issued by the OC Tamulpur PS, vehicle number, engine number, and chassis number was involved in the accident. The CW1, that is the claimant in her evidence, stated that on the day of accident, her husband was proceeding from Tamulpur side towards Bahbari by riding the motorcycle bearing engine number so-and-so, chassis number so-and-so. And on his way, when he reached at Kumarikata, all of a sudden, the said motorcycle met with an accident due to its mechanical defect, as a result of which the deceased sustained grievous injury on his person and died during the course of treatment at downtown hospital. From the above noted evidence, it is appeared that the accident took place while the deceased used the vehicle. I have gone through the police report. The opposite part, I have gone through the police report. The opposite party side did not adduce any rebuttal evidence to show that the deceased did not die due to motor vehicle accident. In view of the above evidence of the claimant and in absence of any legal evidence, it is crystal clear that the accident took place due to use of the vehicle number so-and-so, and the injured sustained injury in the said accident and died later on. Hence, this issue is decided in favor of the claimant side. Issue number 2. This issue relates to reliefs to be granted to the claimant to its extent. Now coming in the question of compensation, I find the claimant claim rupees 10 lakhs. Before proceeding further, let me consider whether the claimants are entitled to get compensation as claimed for or not. The claimant stated in her evidence that the deceased was an employee of Jagrota Shiv Mandir Lottery Committee and he borrowed the vehicle. Lordship will mark this borrowed the vehicle, Lordship. Borrowed the vehicle from the said committee for his business purpose. The learned counsel for the OP1 has stated that, filing written argument, that as per section 163A of the Act, the borrower of a vehicle is to be considered as the owner of the vehicle. In support of her argument, she has referred to the case law of Honorable Apex Court in Ningamma and another versus United India Insurance Company Limited, reported in so-and-so. Therein, it was held that where borrower of the vehicle died in the accident, his legal heirs are not entitled to claim compensation. But here in this case, the claimant has not submitted any document to show that the deceased was the employee of Jagrata Shiv Mandir Lottery Committee. Even the OP1 has not made any attempt to prove any person from such committee to prove that the deceased was the employee of said committee. Hence, in my considered view, the claimant are not entitled, are entitled to get compensation. We will be agitating this part of the judgment mainly, Lordship. For assessing the compensation, the claimants are required to establish three things in instant case: age of deceased, income of deceased, number of dependents. The claimant number 1 stated in the claim petition that the age of the deceased, that is her husband, at the time of death was 28 years. The claimant has not submitted any document to prove the age of the deceased. On the other hand, on perusal of the postmortem examination report, it appears that at the time of accident, the deceased was 28 years old. So I am constrained to hold that the age of the deceased was in the age group of 25 to 30 years at the time of his death. As per second schedule of MB Act, the multiplier for the age of 25 to 30 is 18. In view of above, age of deceased, multiplier 18 has to be taken for ascertaining the loss of dependency in this instant case. Coming to the second component, the claimant has stated that the deceased was a businessman and his monthly income was rupees 3,000. But the claimant has not submitted any document to prove the income of deceased. Hence, in absence of any positive evidence of income of deceased, notional income of rupees 3,000 is taken as the income of deceased for assessing the compensation. Considering all facts and circumstances of the case, I find it just and equitable to hold the monthly income of the deceased was 3,000. So far as the third component is concerned, the deceased left behind three dependents, that is his wife, daughter, and his mother. Father is not considered as dependents, hence the assessment of compensation is detailed as follows. Then that compensation is calculated. Besides lots of dependents, the claimant is also entitled to funeral expenses as well as amount for general damages as per the decision of Apex Court in Rajesh versus. This is also not correct. I will come to pronunciative with this, Lordship, the amount given in the compensation. Because Rajesh and Rasbir has been nullified by Apex Court. As per the decision of Apex Court in Rajesh and others versus Rajbir Singh and others. The award of funeral expense and consortium, some general damages are awarded as follows. Then another list of other damages are given, Lordship. Then the amount comes to 6,67,000. The offending vehicle was insured with OP number 1 and was under valid policy coverage at the time of accident is not in dispute. Hence, OP1 is to satisfy the award to the claimants. This issue is decided accordingly. In the result, the claim petition is partly allowed. Claimants are awarded a total compensation of 6,67,000 for the death of deceased Mainul Ali in a motor vehicle accident. OP1 insurance number 1, insurance company is directed to pay the awarded amount to the claimants within 90 days from today, that is Iman. The amount of compensation shall carry an interest of 6% per annum from date of filing the claim till its realization. Out of the awarded amount, rupees 1 lakh will be fixed deposit in the name of claimant number 2 in any nationalized bank of her home district till she attains her majority. Out of the amount, rupees 2 lakh is awarded to claimant number 3, who is the mother of the deceased. The OP number 1, that is insurance company, shall be entitled to deduct the interim compensation paid to the claimant, if any. Send a copy of judgment to OP number 1, that is insurance company, for information and necessary payment given under my hand and seal. So, Lordship, first of all, I'll give the judgment, Lordship. Already, I think it is given, Ningamma judgment, Lordship. Why the court, again, to reiterate what the trial court did, Lordship, I'll read that. 63 Ningamma, wherein it is held that when borrower of the vehicle died in the accident, his legal heirs are not entitled to claim compensation. That is discussion about Ningamma. But here in this case, the claimant has not submitted any document to show that the deceased was an employee of Jagrata Shiv Mandir Lottery Committee. That is not required, Lordship, as per Nanjappan, Ningamma. I'll take, Lordship, to Ningamma's paragraph 21.
Who is the registered owner of the vehicle?
They are They are Jagrata Shiv Mandir Lottery Committee.
In RC, their name has been reflected.
Yes, they are party, Lordship.
Okay.
I don't know, their service was complete. They have not, no, they filed wakalatnama.
Yes, proceed.
Yes. So Lordship will take up the Ningamma judgment, paragraph 21, Lordship. Here the court is saying, the trial court is saying that the claimant has not said he was working under the committee and he was employee of Jagrata Shiv. That is not required, Lordship. It is only someone borrowing the vehicle, he steps into the shoes of the owner of the vehicle. Paragraph 21, Lordship. Ningamma.
Yes.
In our considered opinion, the ratio of decision in Oriental Insurance Company Limited, this is Rajni Devi, that is at paragraph 19 mentioned, Lordship, is clearly applicable to the facts of the present case. In the present case, the deceased was...
Read 19 also.
In Oriental Insurance Company Limited versus Rajni Devi, wherein one of us, namely Honorable S.B. Sinha J, was a party, it has been categorically held that in case where third party is involved, the liability of the insurance company would be unlimited. It is also held in the said decision that where, however, compensation is claimed for death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract qua contract, the claim of the claimant against the insurance company would depend upon the terms thereof. That's why I said, Lordship, that 1 lakh rupees that they will be entitled to, because as per the contract, 50 rupees was paid for the owner. Then 20. It was held in Oriental Insurance Company Limited case that section 163A of the MV Act cannot be said to have any application in respect of an accident wherein the owner of the motor vehicle himself is involved. The decision further held that the question is no longer res integra. This point, Lordship, not only in Rajni Devi, I have other case also, Jumma Sahar also, there also, when the owner himself is responsible, they cannot claim that is given, Lordship. The decision further held that the question is no longer res integra. The liability under section 163A of the MBA is on the owner of the vehicle. So a person cannot be both a claimant as also a recipient with respect to claim. Therefore, the heirs of the deceased could not have maintained a claim in terms of section 163A of the MBA. In our considered opinion, the ratio of the decision in Oriental Insurance Company Limited case is clearly applicable to the facts of the present case. In the present case, the deceased was not the owner of the motorbike in question. The Lordship, here I'll pause and I'll mention that in the judgment of the tribunal also, the tribunal has come to the finding that he was not an employee of the committee. He borrowed the said motorbike from its real owner. That also I read, Lordship, borrowed. The court has come to that. The deceased cannot be held to be an employee of the owner of the motorbike, although he was authorized to drive the said vehicle by its owner, and therefore he would step into the shoes of the owner of the motorbike. We have already extracted section 163A of the MBA herein before. A bare perusal of the said provision would make it explicitly clear that person like the deceased in the present case would step into the shoes of the owner of the vehicle. In a case wherein, Lordship, should I read or it is clear? Then I can go to our High Court judgments, Lordship, wherein this was followed and it was directed that it will be as per the policy.
Read 22.
In a case wherein the victim died or where he was permanently disabled due to an accident arising out of the aforesaid motor vehicle, in that event, the liability to make payment of the compensation is on the insurance company or the owner, as the case may be, as provided under section 163A. But if it is proved that the driver is the owner of the motor vehicle, in that case, the owner could not himself be a recipient of compensation, as the liability to pay the same is on him. This proposition is absolutely clear on the reading of section 163A of the MBA. Accordingly, the legal representatives of the deceased who have stepped into the shoes of the owner of the motor vehicle could not have claimed compensation under section 163A of the MPA. When we apply the said principle into the facts of the present case, we are of view that the claimants are not entitled to claim compensation under section 163A of the MPA, and to that extent, the High Court was justified in coming to the conclusion that the said provision is not applicable to the facts and circumstances of the present case. However, the question remains as to whether an application for demand of compensation would have been made by the legal representative. Lordship, this again, it is regarding.
Read 24 also.
I'll read whole then, Lordship, because this is relating to whether it can be 166.
Yes.
And then we go to Dipal Girish Bhai Soni, where two things are given: 163A, when there is no ration, when no other vehicle is involved, then 163A people can file if only one vehicle is. And under 166, they have to prove ration negligence
On the other one.
on the other vehicle.
Okay, read
On
20.
own ration negligence, they will not get. That is Rajni Devi also. However, the question remains as to whether an application for demand of compensation could have been made by the legal representatives of the deceased as provided under section 166 of MPA. The said provision specifically provides that an application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 may be made by the person who has sustained the injury, or by the owner of the property, or where death has resulted from the accident, by all or any of the legal representatives of the deceased, or by any agent duly authorized by the person injured, or all or any of the legal representatives of the deceased, as the case may be. When an application of the aforesaid nature claiming compensation under the provision of section 166 is received, the tribunal is required to hold an inquiry into the claim and then proceed to make an award, which, however, would be subject to the provisions of section 162. By determining the amount of compensation which is found to be just, person or persons who made claim for compensation would thereafter be paid such amount. When such a claim is made by the legal representatives of the deceased, it has to be proved that the deceased was not himself responsible for the accident by his ration negligence. This will be important, Lordship. If it is converted to 166, then they have to prove that deceased was not himself responsible for the accident. It would also be necessary to prove that the deceased would be covered under the policy so as to make the insurance company liable to make the payment to the heirs. In this context, the reference would be made to a relevant para of section 147 of the MBA, which reads as follows. Requirement of policies and limits of liability. In order to comply with the requirements of this chapter, a policy of insurance must be a policy which A, is issued by a person who is an authorized insurer, and B, insurer insures the person or classes of persons specified in the policy to the extent specified in subsection 2. Then Roman 1, against any liability which may be incurred by him in respect of the death or bodily injury of any person, including owner of the goods or his authorized representative, carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. 2. Against the death of or bodily injury to any passenger of a public service vehicle caused by or arising out of the use of the vehicle in public place. Provided that a policy shall not be required to cover liability in respect of death arising out of or in course of his employment of the employee of a person insured by the policy, or in respect of bodily injury sustained by him by such an employee arising out of and in course of his employment, other than a liability arising under the Workmen Compensation Act 1923, 8 of 1923, in respect of the death of or bodily injury to any such employee. A, engaged in driving the vehicle, or B, if it is a public service vehicle, engaged as a conductor of the vehicle or in examining tickets on the vehicle, or if it is a goods carriage being carried in the vehicle, or to cover any contractual liability. 2. Subject to the provision of subsection 1, a policy of insurance referred to in subsection 1 shall cover any liability incurred in respect of any accident up to the following limits, namely A, save as provided by clause B, the amount of liability incurred. B, in respect of damage to any property of a third party a limit of rupees 6,000, provided that any policy of insurance issued with any limited liability or in force immediately before the commencement of this act shall continue to be effective for a period of 4 months after such commencement or till the date of expiry of such policy, whichever is earlier. Notwithstanding anything contained in any law for the time being in force, an insurer issuing a policy of insurance under this section shall be liable to indemnify the person or classes of persons specified in the policy in respect of any liability which the policy purports to cover in the case of that person or those classes of person. 27. Section 147 of the MBA provides that the policy of insurance could also cover cases against any liability which may be incurred by the insurer in respect of death or fatal injury to any person, including owner of the vehicle or his authorized representative carried in the vehicle or arising out of the use of the vehicle in the public place. 28. When we analyze the impugned judgment of the High Court in terms of aforesaid discussion, we find that the counsel for the insurance company himself contended before the High Court that the policy of insurance was an act policy and the risks that is covered is only in respect of person contemplated under section 147 MBA. But Lordship, I will pause here. In our case, the premium was paid. It is not an act policy. Comprehensive policy. That's why I said 1 lakh rupees. It is the finding of fact which we have also upheld in this judgment that the deceased was authorized by the owner of the vehicle to drive the vehicle. When we examine the facts of the present case in view of the aforesaid submission made, we are of opinion that such an issue was required to be considered by the High Court in light of the facts and evidence adduced in the case. On consideration of the judgment and order passed by the High Court, we find the same to be sketchy on the aforesaid issue as to whether the claim could be considered under the provision of section 166 of the MBA. In this connection, reference may be made to the judgment of this court in Oriental Insurance Company Limited versus Rajni Devi, wherein it was held that where compensation is claimed for death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract, the claim of the insurance company would depend upon the terms thereof. Recently, this court in Rajrani versus Oriental Insurance Company Limited, wherein one of us, Honorable S.V. Sinha J, has taken the view that it is not necessary in a proceeding under the MBA to go by any rules of pleading or evidence. Section 166 of MBA speaks about just compensation. The court's duty being to award just compensation, it will try to arrive at the said finding, irrespective of the facts as to whether any plea in that behalf was raised by the claimant or not. It was further observed in Rajrani case that although the multipliers specified in the second schedule appended to the MBA are stricto sensu not applicable in case under section 166 of MBA, it is not of much dispute that wherever the court has to apply the appropriate multiplier, having regard to several factors in mind, the court has placed reliance on earlier judgment of this court in Nagapa versus Gurudayal Singh, wherein it was observed as follow in para 7. Firstly, under the provision of the Motor Vehicle Act 1988, hereinafter referred to as MP Act, there is no restriction that compensation could be awarded only up to the amount claimed by the claimant. In an appropriate case where, from the evidence brought on record, if the tribunal court considers that the claimant is entitled to get more compensation than claimed, the tribunal may pass such award. The only embargo is it should be just compensation, that is to say, it should be neither arbitrary, fanciful, or unjustful from the evidence. This would be clear by reference to the relevant provision of the MP Act. Section 166 provides that an application for compensation arising out of an accident involving the death of a bodily injury to a person arising out of the use of motor vehicle or damage to any property of a third party so arising or both could be made A, by the person who has sustained the injury, or B, by the owner of the property, or C, where the death has resulted from the accident by all or any of the legal representatives of the deceased, or D, by any agent duly authorized by the person injured, or all or any of the legal representatives of the deceased, as the case may be. Under the provisions proviso to subsection 1, all the legal representatives of the deceased who have not joined as claimants are to be impleaded as respondents to the application for compensation. The other important part of the said section is subsection 4, which provides that the claims tribunal shall treat any report of accident forwarded to it under section 6 of section 158 as an application for compensation under this act. Hence, the claims tribunal is in an appropriate case can treat the report forwarded to it as an application for compensation, even though no such claim is made or no specified amount is claimed. 33. There are indeed cases like New India Insurance Assurance Company Limited versus Sadanand Mukhi, wherein the son of the owner was driving the vehicle who died in the accident was not regarded as third party. In the said case, the Honorable Court held that neither Section 163A nor Section 166 would be applicable. This case also I will be submitting, Lordship. Undoubtedly, Section 166 of the MBA deals with just compensation, and even if in the pleadings no specific claim was made under Section 166 of the MBA, in our considered opinion, a party should not be deprived from getting just compensation in case the claimant is able to make out a case under any provision of law. Needless to say, the MBA is beneficial and welfare legislation. In fact, the court is duty bound and entitled to award just compensation, irrespective of the fact whether any plea in that behalf was raised by the claimant or not. However, whether or not the claimants would be governed by the terms and condition of the insurance policy and whether or not the provision of Section 147 MBA would be applicable in the present case, and also whether or not there was rash and negligent driving on the part of the deceased are essentially a matter of facts which are required to be considered and answered at least by the High Court. While entertaining the appeal, no effort was made by the High Court to deal with the aforesaid issues, and therefore we are of the considered opinion that the present case should be remanded back to the High Court to give its decision on aforesaid issue. The High Court was required to consider the aforesaid issue even if it found that the provision of Section 163A of MBA was not applicable to the facts and circumstances of the present case. Since all the aforesaid issues are purely question of fact, we do not propose to deal with these issues, and we send the matter back to High Court for dealing with the said issues and to render its decision in accordance with law. The High Court will also consider the question of quantum of compensation, if any, to which the claimant might be entitled to, having regard to the earning capacity of the deceased, and just compensation, if any. Since the claim is very old claim, we request the High Court to consider the matter as expeditiously as possible. In terms of aforesaid order, we remand back both the matters to the High Court to dispose the same. The appeal are disposed of in terms of the aforesaid order. So this.
Yes.
Then, Lordship, Lordship, the finding of the tribunal of the judgment, because in this case many things are decided. Our relevant part is paragraph 21, Lordship, and the tribunal, Lordship, what it did, that he was not employee of the owner of the vehicle. That was stated.
Which
And
was, according to you, not required.
that is not
The
required.
question to be ascertained was whether the vehicle was his own or is a borrowed vehicle.
Yes, and court came to the finding he borrowed the vehicle. At page 9, Lordship, of my memo of appeal, line 1, 2, 3, 4, 5, 6, 7, seventh line, court came to that finding because that was the evidence adduced. Otherwise, how can someone take a motorcycle, Lordship, if it is not borrowed? Otherwise, he will be stealing.
No, though claimant stated that he borrowed the vehicle, but court did not made any observation. Claimant stated that the deceased borrowed the vehicle from Jagrata committee.
But the court came to the wrong conclusion that
That he was not employee.
It is not necessary to be an employee. Borrowing is, if my vehicle is taken by somebody and I allow them to take it, then it is borrowed. And that is the question which was in Ningamba that was decided. And our High Court, Lordship, in, I'll give one by one or all?
Only one.
Only one.
Because you are already relying on a Supreme Court judgment.
Yes, and these judgments.
So don't give don't bombard judgments.
Okay, Lordship.
Only one judgment. Give your
I have to choose the,
best judgment.
no, all the judgments are best judgments, Lordship, because I appeared in them. So, and
So it sounds like because you appeared, therefore they are best judgment.
yes. I'll
Give one judgment. Because it according to you, relies on
Ningam.
Ningamma's case. So base judgment you have already discussed.
Because these judgments, Lordship, our High Court judgment, they are not relying only on Ningamma, but also Sadanand Mukhi and the judgments that are mentioned in Ningamma. This one I'm giving, very reluctantly, I'm giving one, Lordship.
Now give one more.
One more. I'll give the Pushpa Kokretwa also. And Lordship, one of Supreme Court, that is Jumma Saha, that I'll come to Lordship later on.
This Umakanti Kumar.
Umakanti Kumar, Lordship, paragraph 6 and 10.
What it says regarding that if he has borrowed it from the owner,
yes,
then he comes into the shoes of owner.
Yes, and 10, Lordship, that entitlement of 1 lakh rupees. At the back, at paragraph 10 and 11, 10 is stepping into shoes, and 11, however, the petitioner is at liberty to approach the insurance for getting the amount given under the policy against the premium that was paid against the owner, which will cover about rupees 1 lakh.
Okay, then this
Kukrechwa also, Lordship, Pushpa Kukrechwa also discussed those. And paragraph 7, Ningamma is discussed, and paragraph 10, Lordship. Here, Lordship, in this Pushpa Kukreshwar, like our present case, Lordship, we had deposited the amount. The court directed that 1 lakh to be given to the claimants and rest of the amount to be given back to the insurance company.
Yes, anything else?
Yes, and another judgment, Lordship, of Apex Court I'm giving, wherein the owner himself, the deceased was the owner, and he, because of his own negligence, the accident took place. So though the case was filed under section 163, Apex Court held that for his own negligence, he cannot, a person like Rajni Devi, Ningamma, it is mentioned, I'm not giving Rajni Devi case. There also it was said that for his own negligence, the person cannot get it. So Jumma Saha also, that I too did. So anything else he says, Lordship, I'll give a reply.
Yes, may I please, your Lordship? My Lord, whatever the submission made by the learned counsel, my Lord, the citation is not attracted. It is attracted in case of borrower of the vehicle. The deceased person was not the borrower of the vehicle. He was an employee of that Monday committee. Kindly peruse the policy, page, my Lord, page 20. It was in the name of Jagrata Shiv Mandir, and accident occurred during the period of valid period of that policy, my Lord. And he was an employee, and that was proved by the claimant number 1, who had adduced her evidence during trial. And that was not disputed by insurance company. And during cross-examination also, insurance did not raise this issue. And for the first time, at the time of filing appeal, they have raised this issue. And during cross-examination, it was not disputed. And during trial,
no, but the tribunal held that you failed to prove that you are employed.
Yes, but the insurance did not raise this question.
And one more thing, the tribunal also held that the claimant herself stated that you borrowed the vehicle.
But my Lord, he was an employee of that Monday committee. And during trial, my Lord, the insurance was given ample scope to file evidence in case of their defense. But the insurance did not file any evidence.
So how it is different? Suppose he is an employee.
Yes, my Lord. Since both the
employee falls under the peripheral of Mondir committee, my lord. And once Mondir committee is insured, so it will automatically covers in case of employee. My respectful submission before this honorable court. And the learned trial court doing trial
No.
raised.
Basically, her submission is that
Yes.
under section 163A,
63.
it is the owner who is liable to pay
Yes.
the compensation.
Yes. And her submission that he.
And when a vehicle is borrowed from the owner, borrower steps into the shoes of the owner, and therefore owner himself cannot compensate the owner. That is the principle.
That is the
which-
principle, but in this case, my lord, the learned trial court framed two issues, and both the issues affirmed by the learned tribunal. And the opposite party did not adduce any rebuttal evidence during trial. So my respectful submission before this honorable court that the learned tribunal rightly passed that judgment because this person was the source of income of his family, and at the time of passing the order, my lord, the learned tribunal slightly partly allowed that claim petition and further held that father of the deceased person is not entitled, but after going through all the documents that was adduced by the claimant.
No. You counter her submission that Ningama's judgment is not applicable to your
Yes, my lord.
case.
That is not applicable.
Why?
Because he was an employee, and at the time of adducing evidence by the claimant number 1, my lord, that was not disputed by the insurance. PCR is also available on record, my lord. My lord, and during trial at the time of adducing evidence, exhibit 1 was Form 54, which reflects that yes, on that fateful day, accident occurred, and due to accident, the father of the claimant expired, and in the postmortem report also reflects that.
No, where is the evidence that he was an employee?
Yes, my lord, but since
Because there is an observation in the impugned judgment
yes, my lord, since
of the tribunal which says that claimant fails to produce any document.
since statement was made on affidavit, and that was not disputed by the insurance during trial. So claimant, after losing her husband, whatever the submission made before the learned tribunal, it was
Suppose if he is assuming that he is an employee of Jagrata Society,
yes,
then Ningama's case, according to you, is not applicable.
no, he was not
Why?
a borrower. He was not a borrower. He was an employee during that period, my lord. Because, my lord, kindly peruse, my lord. Page 7, my lord. Para 6, my lord. During course of trial, the claimant side has examined one witness by filing evidence on affidavit, and contesting opposite insurance company has not cross-examined the claimant's witness.
Has duly cross-examined.
Duly cross-examined the claimant's witness. Contesting opposite insurance companies has not adduced any defense evidence. Well, they totally failed to adduce evidence.
Okay, where is the evidence that evidence of claimant?
Well,
What she stated regarding the
that is available on record, my lord. PCR is available, my lord. And
what you stated before the
that
tribunal.
my husband, claimant number 1 adduced.
What she stated before the tribunal.
Yes.
What she has stated.
He was.
You are submitting that she adduced evidence that he was an employee of Jagrata.
Yes.
Where is that? First of all, where is that?
Para 3, my lord. death on fateful day of accident on 6/2/2011, while my husband, Moinul Ali, as an employee of Jagrata Shiv Mandir Lottery Committee and riding vehicle engine number such and such, chassis number such and such, proceeding from Tamulpur side towards Babari for the business purpose of the said committee, and the vehicle met with accident due to mechanical defect, as a result of which the deceased husband
So
fall
your
down.
submission is to an employee of
Yes,
an owner. This principle of Ningama will not be applicable.
Yes, my lord. I was not the borrower of the vehicle.
Okay.
I was performing my duty and on the fateful night, and that was not disputed by the insurance company. And my lord, what about the loss faced by the claimant? It was totally irreparable loss. And insurance, since my lord is countering that he borrowed the vehicle, so it's totally wrong.
Okay. On this, you have any
Yes, Lordship.
counter?
He is-
Anything else?
And this is my limited submission.
Now, Lordship, if he says he is the employee, he does not get anything.
Why?
Because, Lordship, no premium was paid. And their contention is that he was a businessman. If he was a businessman, how he is an employee? It is their own submission. It is mentioned in their evidence also that he was a businessman. No premium. I was saying about that 1 lakh because, Lordship, compulsory PA cover owner driver was paid, Lordship. That's why they will get 1 lakh. That is what I submitted.
No, my lord.
But there was, and he has mentioned about the policy. You will find
Yes,
that
whole policy is annexed. In
it
page
is all
20.
zero.
But accident.
The legal liability cover paid drivers. He was not a paid driver, Lordship. That is also, still it is zero. No premium was paid. Then
But-
they do not get anything.
Policy was in the name of Jagrata Shiv Mandir, my lord. And accident occurred during Phelit period, my lord.
We are not disputing, no one is disputing the policy.
Heard Miss Adi Majumdar, the learned counsel for the appellant. Also heard Mr. What is your name?
K. Kolita.
Which item number?
Item 10.
Also heard Mr. K. Kolita, learned counsel for respondent number 1. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 19/12/2013 passed by the Motor Accident Claims Tribunal number 2, Kamrup, in MAC case number 1126/2011, whereby the appellant was directed to pay a compensation amount of rupees 6,67,000 to the claimants on account of the facts, next paragraph, the facts relevant for consideration of the instant appeal, in brief, are that the present respondent number 1, 2, 3, and 4 have filed an application under section 163 capital A of the Motor Vehicles Act 1988 before the Motor Accident Claims Tribunal number 2, Kamrup at Gauhati, seeking compensation on account of death of Moinul Ali, who was the father of the respondent number 1, who was the husband of the respondent number 1 and father of other claimants. The death of said Moinul Ali occurred in an accident involving motorcycle bearing engine number, see engine number from page 6 of the memo of appeal, A marked A, and chassis number from the memo of appeal. It is contended in the claim petition by the claimants before the Motor Accident Claims Tribunal that on the fateful day, that is on 6/2/2011, the deceased Moinul Ali was proceeding from Tamilpur on the above mentioned motorcycle towards Bahbari, and on his way, when he reached Kumarikata, he met with an accident due to mechanical defect of the motorcycle. Stop. As a result of said accident, the said Moinul Ali sustained grievous injuries on his person, and he was thereafter shifted to hospital. However, later on he succumbed to his injuries. The application under section 163A of the Motor Vehicles Act filed by the respondent/claimants was registered as MAC case number 1126/2011. During the inquiry, the claimant number 1 examined herself as the witness for claimant side, and before that, the present appellant contested the claim of the respondents by filing written statement wherein it took various defenses and pleaded that the insurance company is not liable to pay any compensation to the claimants. Stop. Next para. On the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page 7 of the memo of appeal. Stop. Next para. During the course of inquiry, the claimant side examined one witness and exhibited certain documents. Though the contesting opposite party insurance company cross-examined the claimant witness, however, it did not adduce any evidence on its own. Ultimately, after completion of the inquiry, the claimants were awarded the compensation amount of rupees 6,67,000 by the judgment and award dated 19/12/2013, which has been impugned in this appeal. Stop. Next para. Miss R.D. Majumdar, the learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal had erred in awarding compensation to the claimants, ignoring the fact that
But
there is.
can I just interrupt something, Lordship? He mentioned about the policy. I'm sorry, Lordship. The address in the policy is also of the deceased. Mainul Ali. He was the owner of the.
No, how he can be
It
there.
is there in the policy. I'm just mentioning, Lordship,
Okay.
because I have mentioned in my appeal memo, ground of appeal, Lordship, in A itself, that the policy was given under his Mainul Ali, Doronga Mela, Bajar. I'm just mentioning, Lordship.
Yes. के लिख ले मिस R.D. Majumdar. In ignoring the fact that the accident occurred due to the accident occurred in the accident which resulted into the death of said Mainul Ali. No other vehicle except the motorcycle which he was riding at the time of accident is involved. She submits that the registrations, the offending vehicle was owned by one Jagrata. What is that?
Jagrata Shiv Mandir.
Jagrata Shiva Mandir. She further submits that in the policy against the offending vehicle, in the address, in the place where address of the owner is to be shown, the address of the deceased has been shown, which indicates what according to you?
That in fact he was the owner of the vehicle.
Which indicates that
because it is written address of the insured.
which indicates that the deceased was himself the owner of the vehicle. Stop. She further submits that otherwise also the tribunal erred in failing to consider the evidence on record that to the effect that the offending vehicle was borrowed by the deceased at the time of accident. She submits that in case of a borrower of the vehicle from the owner, he steps into the shoes of the owner and is not entitled to claim compensation under section 163A of the Motor Vehicle Act, apart from what has been agreed in the insurance policy itself. She submits that in the instant case, the risk cover of the owner was only to the extent of rupees 1 lakh, and therefore she submits that there are catena of judgments in which it has been held that when the deceased borrows a vehicle from its real owner, he steps into the shoes of owner of the motor vehicle, and thus he cannot claim compensation from the owner himself. In support of her submission, she has cited following rulings. Ningama and others versus United India Insurance Company Limited, reported in 2009, 13 SCC 710. National Insurance Company Limited versus Srimati Pushpa Kukrachua and 5 others. Within bracket, judgment dated 17/7/2019 in MAC appeal number 96/2015. National Insurance Company Limited versus Srimati Uma Kanti Kumar, judgment dated 8/8/2018, reported in MAC appeal number 313/2014. She further submits that even if the claim petition filed by the regarding conversion, you have any submission?
Lordship,
If it is treated as 166.
then also he won't get. I've given Jumma Saha because it was
She
his own
further
name.
submits that
And Rajni Devi.
even if the claim petition filed by the claimants before the tribunal under section 163A is treated as an application under 166 of the MV Act, still the claimants were under obligation to show that the accident occurred due to fault of some other vehicle, and the applicant and the deceased was himself not negligent in any manner, which they have failed to show.
I will cite this judgment, Lordship, 2008 5 SCC 736, Oriental versus Rajni Devi. It is mentioned in Ningamma also. And also,
Support of her submission, she has cited ruling of the apex court, following rulings of the apex court. Oriental
2008 5 SCC 736, Oriental Insurance Company Limited versus Rajni Devi.
as well as
2007 9 SCC 263, Oriental Insurance Company Limited versus Jumma
Saha and others. On the other hand, Mr. K. Kalita, the learned counsel for the respondent/claimant, has submitted that there is no infirmity or illegality in the impugned judgment, and the Motor Accident Claims Tribunal has correctly awarded the compensation amount to the claimants after considering the evidence on record. He submits that the deceased was not a borrower of the offending vehicle from the owner of the vehicle. Rather, he was an employee of the owner, and there is categorical evidence to this effect in form of the evidence on affidavit submitted by the claimant number 1 before the tribunal. He submits that the accident occurred due to mechanical defect of the offending vehicle, and the deceased was not at fault in any manner. He also submits that the judgment, the ratio of the ratio decidendi of the case in the case of Ningamma and another versus United in India Insurance Company Limited within bracket Supra is not applicable to the present case as rightly held by the Motor Accident Claims Tribunal. Anything else?
Well, since the loss was irreparable loss and the learned court always relies upon a document, and learned tribunal, after going through the evidence on
He also submits that the
was pleased to pass that judgment.
the insurance company also failed to adduce any evidence during the inquiry before the Motor Accident Claims Tribunal. Therefore, he submits that the appeal is liable to be dismissed. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the ruling cited by the learned counsel for the appellant in support of her submissions. Reserved.
Lordship, only one thing that we had deposited 8,05,585. That may be released if Lordship would by
How much?
8,05,585.
What was the
No, because Lordship, they filed one execution case. So even before the delay, they did not appear in the court, but they filed an execution case. So in the before
that has been taken by you?
no,
No, my lord, that is not, order is not passed in connection of IAC 3886/2025. That is still pending. I
that
prayed
is
for
Lordship Kukrashua judgment that whatever is deposited, they will get 1 lakh, and rest of the amount maybe that is what I am submitting. Rest of the amount may be allowed to be withdrawn by the
for the interest of
appellant
justice,
company.
my lord.
And Lordship, statutory deposit. Can I finish?
Yes, yes.
Yeah. Statutory deposit which we have, that Lordship will allow refund of that.
Okay.
At least that judgment may kindly be upheld, my lord, for the interest of justice.
It is legal. They said ki we did not deduce evidence. That is not necessary, Lordship. It is better not to
it's a
deduce
part of the
evidence
proceeding.
in cases
It is a
where
part of
it
the
is
proceeding.
proved by them what is the case, what is
And-
our case, Lordship.
That was not disputed
Okay, wait
during
for the
cross-examination,
judgment.
my lord.
Heard so and so. Hearing concluded, judgment reserved. Judgment reserved.
Highly obliged.
Obliged.
One more thing, Nalan. Where is the other side?
They were here. 5 minutes before I was. Lordship, if Lordship allow, let me take the Lordship for the judgment, trial for judgment.
Yes,
Meantime, they may come.
yes. You are the claimant or insurance
I am the
company?
claimant, Lordship.
On what are the grounds?
application filed by the owner and the driver. There is no insurance.
Appeal has been filed by owner.
Owner and the driver, both.
Okay. What are their grounds?
Their ground is the
No, you can go, take me through the judgment.
judgment, Lordship. Lordship, the judgment is page 155 of the appeal memo. Under 55.
There is no insurance company.
No insurance company.
Why? The judgment, the vehicle was not insured.
Not insured. Lordship.
My lord, time being, your lordship, my seniors on that side.
Lordship, let me go through it. Again, time will
He'll be coming or not?
Yeah, he will be coming, your lordship. He's online.
Let me give my submission. Then they will come, Lordship.
Yes, you may start. You start.
I will start, Lordship. Lordship, may I?
Yes.
This MAC case has been filed by the claimant, Sri Atul Pathak, as well as his wife and his daughter, claimant number 2 and 3 respectively, under section 166 and 140 of MV Act, claiming compensation for OP number 1, owner, and OP number 2, driver of the offending vehicle, Chevrolet Spark, bearing registration number so and so, to the tune of rupees 75 lakhs, for cause of death of their son, her brother, Vishnu Jyoti Pathak, in a motor vehicle accident which took place at Jorabari on 31/1/2015 involving the aforesaid vehicle. According to the claimant, on the date of the accident on 31/1/2015, the deceased Vishnu Pathak was traveling in a vehicle bearing number MS14BX1288 from Pathali Pahar to Charaidoloi, and when they reached Jorabari, it missed with an accident when the vehicle knocked a roadside tree, as a result of which he sustained injury and died. According to the claimant, the accident occurred due to rash and negligent driving of the driver of the offending vehicle. All the opposite party contested the case by filing written statement. OP number 1, the owner of the offending vehicle, in his written statement, has stated that he is working in a research work at PTWIN Win-Win Rubber Techno-Win, Panbil Industry Estate Factory B2A, Balan, so-and-so, Indonesia, and therefore residing in Indonesia. The owner is residing in the Indonesia. He has stated that when he was in India, he brought a car bearing so-and-so, and before leaving Indonesia, he sold out his above-mentioned car to his younger brother, Sri Jitendra Pathak, OP number 2, executing an agreement for sale on 5/5/2014. But your lordship, this agreement for sale is neither registered, neither notarized. And the copy available in the trial court record is the photocopy.
They are shifting actually burden to new purchaser. Whether new purchaser is a party.
Yes, but he's okay. He's the OP number 2.
Here in appeal, he's
appellant. He's the appellant number 2.
He's the appellant.
He's the appellant.
Okay.
Here, appellant number 1 is the owner, and appellant number 2 is the new purchaser, come driver.
Okay. And both are represented by same counsel.
Same counsel. Same counsel.
Okay.
Executing an agreement for sale on 5/5/2014. In the state agreement sale, it was specifically mentioned that the buyer is solely responsible and liable for any accident, offense, and disputes regarding the vehicle. Accordingly, he put his signature in form number 30, Assam of transfer of ownership of a motor vehicle at part 1 for the use of transferee, and also put his signature in form number 29, Assam schedule 41, part 4, rule 55(1). Therefore, before leaving for Indonesia, the OP1 performed all his duty for transfer of ownership from him to the buyer, OP number 2, as they have made application for transfer of ownership against the aforesaid vehicle before the DTO Lakhimpur. Again, on 6/5/2014, OP number 1 made an agreement for sale in Assamese in non-judicial stamp paper, saying that he sold out his above-mentioned car
in presence of witness against a payment of rupees 1,20,000 to OP number 2. On 36/2040, the PT Win-Win Rubber Technology Panbari Industry State Factory B2N Balan, Indonesia offered him, and accordingly he went to Indonesia and joined the said company. OP number 2, Jitendra Pathak, who is the younger brother of OP number 1 and owned the vehicle by possessing it, was driving the same. On 31/2015, their cousin, namely the Visnujyoti Pathak, the disease here, Visnujyoti Pathak, by pursuing OP number 2, took him to attend a function at night, and while they were coming back from function, a heavy vehicle was coming from opposite side, and said Visnujyoti Pathak, who was in intoxicated state, jumped from the car out of fear. Lordship, how can a person jump out of a running vehicle? It has never been proved. It has been jumped out of the running vehicle. OP number 2, who was driving the car, became nervous and could not control the car, and there was a collision of the car with a big tree. OP number 2 also sustained injury, but unfortunately, Visnujyoti Pathak, who jumped from the car prior to his collision with the tree, sustained injury due to his own fault and ultimately died. We is maintained herein that the cause of death of the disease was not due to collision of the car with the tree, but as because he left the car by jumping out of it prior to the collision. The case is mainly based on this fact, Lordship. That is not due to the collision with the tree. It is due to the disease had jumped out of the car before the collision. As a family member of the disease, Visnujyoti Pathak, the OP number 1, after taking leave from his company, visited his native residence in the district of North Lakhimpur. Further, in apprehension of legal complication, as claimants were contemplating to initiate this claim, OP number 1 executed special power of attorney on 24/2050, whereby nominating and constituting and appointing his mother, Sri Niru Datta Pathak, as attorney regarding any legal complications, steps that may arise out of the state-sold vehicle. Therefore, mother of OP number 1, being an attorney holder, is filing this WS on the behalf of OP number 1. Annexer A is the power of attorney dated 24/2015. He has also denied the avertment made by the claimant in the claim petition, and also stated the claimant number 1 and 2 have one married daughter, namely Delhi Pathak, is about 36, who is working as a constable in Assam Police, and she is earning about rupees 22,000 per month. Claimant number 3 is also working in a private school and earning about 5,000 per month. So they are not dependent on the income of the disease. Therefore, the answering OP is no way connected with the accident and is not liable to pay compensation, as the vehicle in question was already sold to OP number 2 prior to the accident, and case is liable to be dismissed. OP number 2 has corroborated the written statement made by the OP number 1 and has stated that due to some unavoidable circumstances, he could not transfer the registration to his name. So it is admitted that the registration of the car is still in the name of OP number 1. He has also further stated that on 31/1/2015, their cousin, namely Visnujyoti Pathak, by pressuring the OP number 2, took him to attend a function at night, and while they were coming back from a function, a heavy vehicle was coming from the opposite side, and said Visnujyoti Pathak, who was in intoxicated state, jumped from the car out of fear. OP number 2, who was driving the car, became nervous and could not control the car, and there was collision of the car with a big deal. OP number 2 also sustained injury, but unfortunately, said Visnujyoti Pathak, who jumped from the car prior to his collision with the tree, sustained injury to his own fault and ultimately died. Be it mentioned herein that the case of the death of the disease was not due to collision of the car with the tree, as because he left the car by jumping out of it prior to his collision. Claimant has filed this case against the answering OP based on such fact and concocted story, just to illegal gain and harass the answering OP party. Therefore, the case has been filed in the liable to be dismissed. In the WS, they have admitted the OP number 2 has also got injured. Upon the pleading, the parties following issues were framed by the for adjudication. 1. Whether victim Visnujyoti Pathak died in an alleged road accident dated 31/11 involving vehicle number so and so, and whether the said accident took place due to rash and negligent driving of the driver of the offending vehicle. 2. whether the claimant are entitled to get any compensation, and yes, to what extent and by whom among the opposite party, and the said compensation amount will be payable. During the inquiry, the claimant side has examined 3 witnesses and has produced some documents in support of their claim. The contesting opposite party number 1 has examined 1 witness on his behalf. Lordship, this statement is a little bit wrong. The opposite party has not examined 1; they have examined 4 witnesses. Lordship, I've heard an argument for the parties and carefully perused the entire material brought on record, and my finding on the above issues are as follow. Issue number 1 and 2. Both the issues are taken up together for decision and discussion for the sake of convenience and brevity. Evidence of claimant is that on 31/1/2015 at about 9 p.m. while his son Vishnu Jyoti Pathak was traveling in a Chevrolet Spark bearing so-and-so from Pathari Pahar to Sarai Dolnoi and meet with an accident at Zorabari when a speeding vehicle hit a roadside tree. As a result of which her son sustained grievous injury on his person and died. According to her, the accident took place due to rash and negligent driving of the driver of the aforesaid vehicle. Admittedly, she has not seen the accident, and in support of her oral evidence, she has examined 1 eyewitness as PW2. Sri Papu Munda is examined as PW2 and has claimed that he saw the incident. He has stated that on 31/1/2050 at 9 p.m., he was traveling the vehicle bearing so-and-so, same vehicle, from Pathapari to Sarai Dolni, and when they reached Jorabari, it knocked a roadside tree, as a result of which Vishnu Jyoti Pathak was traveling the said vehicle. He sustained grievous injury and died in the accident. He was categorically stated that accident occurred due to high speed and in a rash and negligent manner. No contrary rebuttal evidence has been adduced by the insurer to prove that there was contributory negligence or there was any other cause of accident. In cross-examination also nothing could be brought out to prove that there was any contributory negligence or any other cause.
No, you said that the opposite party adduced 4 witnesses.
Witnesses. They have adduced 4 witnesses. This party is also, they have adduced 4 witnesses.
Insurance company.
Insurance, the owner and driver has adduced 4 witnesses. The owner has
whether the vehicle was insured.
No, it was not insured.
So insurance company is not there in the picture.
No. Insurance very.
So how the tribunal mentioned about insurance? Okay, proceed.
She produced the accident information.
This is factually incorrect.
Factually incorrect.
Okay.
Factually incorrect. I have to admit this is factually incorrect.
Okay, proceed.
She produced the accident information reports at Exhibit 1. We saw that the vehicle number so-and-so was involved in the accident and Vishnu Jyoti Pathak died in the said accident. Nayampur PS registered case via PS case number 32/15 under section 273, 338, 334A IPC against the driver of the offending vehicle. In the FIR Exhibit 2, 1 to 6, it has been mentioned that the offending vehicle was driven in a rash and negligent manner at a relevant time, which caused the accident. Police, after investigation, submitted such sheet against the driver of the aforesaid offending vehicle. Filing of such sheet, Exhibit 3, 1 and 2, is also a prima facie evidence of negligence in case of case under Section 166 of MV Act. Exhibit 4, 1 and 2, as result is the PM report. Exhibit 5 also confirmed that the death was caused due to the injuries sustained by the disease. From the oral evidence of the complainant, coupled with the evidence of eyewitness and available documents produced by her, there is no doubt that the accident took place with the sole negligence of the driver of the vehicle bearing so-and-so. That the vehicle at a relevant time was owned by OP number 1, Sri Kulendra Pathak, has not been disputed, that he has not transferred the ownership of the vehicle. In view of my discussion above, claimant number 1 and 2.
Let him read the judgment. He is reading the judgment.
In view of my discussion above, claimant number 1 and 2, parent of the disease are certainly entitled to compensation. Now, most pertinent question is how much compensation they are entitled to. Only parents were decided to be entitled. The other claimant number 3, the daughter was not considered as entitled for compensation, Lordship, as per the judgment. Claimant has stated that her son was aged about 26 years, 1 month as per Exhibit A, and he was 27 years as per PM report. Exhibit 8 is the admit card of Board of Secondary Education Assam. So his date of birth is 31st December 1988. So he was 26 years, 1 month at a relevant time. Hence, he can therefore be safely placed in the age group 26 to 30 years, and hence appropriate multiplier is 17 as per Sarla Verma versus Delhi Corporation Limited, reported in 2009-6 SCC 121. Regarding income of the disease at the relevant time, according to the claimant, the disease was doing a service as a constable in the 2nd Assam Forest Protection Force, Sisoni, Jaklabanda, Nagaon, and his monthly salary was rupees 19,294 as per Exhibit 7. In this regard, the claimant has examined Siraz Ali, SI of 2nd Assam Forest Protection Force, Sikoni, Jaklabanda, Nagaon, as PW3. He has stated that Exhibit 13 is the authorization letter. He has stated that disease Vishnujyoti Pathak was constable of their department. He has stated that his last pay was 19,294 per month. Total deduction was rupees 2015. Professional tax was 208. He has also admitted that his income does not fall under income tax. Exhibit 7 is a salary certificate issued by their office. Exhibit 7 is the signature of their commandant, Amrit Bhuya, and he know his signature. His job was permanent and his date of retirement was 31/12/48. He has also stated that constable get promotion up to inspector and DSP. He has further prospect. Exhibit 14 is the salary slip, and Exhibit 15, 12 to 14 is the as service book. During cross-examination, he has stated that disease was on leave on the date of accident, but he does not know about the leave. As per Exhibit 7, his gross salary was 19,294 per month, and rupees 208 was professional tax. So after deduction of 208, it comes to 19,086, say 19,000 rupees. Since the disease was below 40 years of age, 50% of his above income is added as future prospect to that income as per the decision of Sarla Verma. Thus, the monthly income of the disease with addition of future prospect would be rupees 28,500, and annual income comes to rupees 3,42,000. Thus, taking the above amount as annual income of the disease, annual loss of dependency after deducting half of the income on account of personal expense of the disease being unmarried comes to rupees 1,71,000. Certain claimants certainly include some amount for the funeral, etc. As such, the besides loss of dependency, claimant is also entitled to amount of rupees 25,000 on account of funeral expense. Thus, the just and reasonable compensation to which the claimant is entitled to in the instant cases assessed as below: loss of dependency 29,07,000, funeral expense 25,000, life and affection 50,000, total 29,82,000. The issues are accordingly decided in favor of claimant. Awarded rupees 29,000.
Yes, Mr. Saikia. He has read out the judgment on it.
I preferred this appeal, my lord, on the ground. First of all, my lord, on jurisdictional ground, my lord. Both the claimant as well as the, my lord, the appellants here in, my lord, the opposite parties in the claim petition, they hails from Lakhimpur, not Lakhimpur. An accident took place in not Lakhimpur, but the claim petition was filed in Gauhati.
But claimant reside in?
No, there is no, my lord, document on record, no evidence on record that he is residing in, my lord, Mirzapur. He has stated in the claim petitions that he was residing in Mirzapur, but nothing was adduced before the learned tribunal regarding that residential status, my lord. That is, my lord. So, my lord, under sections 166(2), the claim petition should not have been entertained.
Okay.
My lord. That is on the ground, my lord. Then, my lord, the wrong appreciation of evidence. There were, my lord, 5 persons in the vehicle, my lord. the petitioner number one, appellant number one, he was the driver. And the deceased was his cousin. Both were sitting in the front seats, my lord. Deceased was sitting in the front left seat, and the appellant number one was sitting driving the vehicle. And three friends were sitting in the back seat. Out of the three, one he adduced evidence as PW1. PW4, I think, my lord. Sorry, my lord.
Opposite parties.
PW1 is
PW2, my lord. PW2. Papu Munda.
PW2.
PW2. He said that, my lord, accident took place due to rash and negligent driving of the
Dashing against a tree.
my lord.
Yes.
But the other two persons who were sitting on the vehicle, they also adduced evidence before the tribunal. They are, my lord, DW3 and DW4. They said that the deceased person, he pulled the, my lord, handbrake of the vehicle. He pulled the handbrake of the vehicle, for which the backside of the vehicle hit the nearby tree on, and the backside of the vehicle got damaged. And the photographs I have annexed, those photographs also clearly indicates that the front side of the vehicle was not damaged. In fact, the backside of the vehicle was damaged. Had the vehicle hit the tree, my lord, the front side should have been damaged. But front side of the vehicle was not damaged. But those evidence were not, my lord, properly appreciated. These three are, my lord, independent witnesses. I'm not saying about the, my lord, appellant number one. He is interested in witness. If he's, my lord, discarded also, the other independent witnesses should have been, my lord, appreciated. Their evidence should have been considered. That has not been done by the learned tribunal. But in the criminal case, on the same incident, my lord, a criminal case was also, my lord, initiated.
What is the number?
That is, my lord, GR number 313-2015, my lord.
Against whom it was?
Against the, my lord, appellant number one, Jitendra Pathak. Appellant number not appellant number one. Is appellant number two, madam, sorry. Appellant number two. That is the judgment of the criminal case, my lord. Here, Lordship will find at paragraph 18. It has been held by the trial court that the accident did not take place due to rash and negligent driving of the driver. In fact, it took place due to pulling of the handbrake of the vehicle by the deceased.
This judgment was produced before the tribunal.
My lord, this was not, my lord, the judgment has been delivered after the judgment in the tribunal.
Then how we can take it into consideration without order 41 rule 27? There is no application.
My lord, the fact remains, my lord, fact remains, this, my paragraph 18 of the judgment clearly indicates that the learned tribunal, my lord, failed to appreciate the evidence on record, my lord.
Lordship, moreover, the finding of the criminal case has no bearing on the administrative proceeding. There are a lot of judgment.
No, wait for your turn.
But this paragraph, paragraph 18 of the judgment.
You may sit.
Paragraph 18 of the judgment clearly indicates that the findings of the learned tribunal is perverse to the, my lord, evidence, because the evidence of the DWs were not considered by the learned tribunal in proper perspective and came to a wrong conclusion that the accident took place due to rash and negligent driving of the driver of the vehicle. if, my lord, that is not proof, no claim.
Deceased pulled the brake.
Yes.
Thereafter, he jumped
My lord, what
outside.
happened, my lord? The appellant, his cousin brother, the deceased, and the three friends, they were, my lord, coming, returning from a view function, my lord. After attending a view function, my lord, they were returning home. On the way, when they were returning home, my lord, from the opposite side, a truck came without using the deeper light. So, my lord, out of fear of accident, the deceased, my lord, pulled the handbrake of the vehicle. And he jumped out. He jumped out because of the, my lord, he fell down of the out of the, my lord, of the vehicle. All the
There were 3 persons sitting on the back seat.
backside. They were inside the vehicle.
Where he was sitting? Middle side?
No, no, the deceased was sitting on the front side, my lord, left side, left seat. Front left seat. And the appellant number 2, my lord, he was driving the vehicle.
Okay.
My lord. Both are cousins, my lord. First cousin, in fact.
Okay.
The other three, my lord, other 4 persons in the vehicle, my lord, they also sustain injuries, my lord. They sustain, my lord, minor injuries because they are inside the vehicle. But the deceased, my lord, he tried to, my lord, jump out of the vehicle, my lord, for which he fell down and he, my lord, he got serious injury, my lord.
Yes, anything else?
Lordship, if your lordship, my lord, peruse the photographs at page 135, the photograph of the vehicle, my lord. This front side and the back side. The vehicle got damaged from the back side, my lord, not the front side, my lord. Had the vehicle hit the tree, my lord, from the front side, it should have been, the front side should have been damaged. Front side was not damaged, my lord. Because of using the, my lord, handbrake, my lord, the vehicle skidded and the back side of the vehicle, my lord, hit the tree, my lord.
How backside can the tree?
My lord, normally, my lord, when a speeding vehicle, my lord, suddenly brake is used, my lord, the handbrake is used, it skids and turns the vehicle.
Okay.
Vehicle turns. And the backside, my lord, hit the tree nearby that road, my lord.
But is there any evidence to that effect?
My lord, the other 2 independent witnesses, they said that, like that, my lord.
That
So,
it's-
if your lordships, my lord, peruses the evidence of, my lord, DW 3 and 4, lordship will find at page 145. 145 DW 3, my lord. From paragraph 3, lordship,
yes,
that in the night of 31/1/2015, one friend of the deponent, namely Vishnu Jyoti Pathak, made the opposite party number 2 agreeable to attend a function at night, taking his car, and also took the deponent and 2 other friends, namely Kukumoni Soikia and Papu Munda, along with them. The car was driven by the opposite party number 2, and I was sitting on the rear left seat. While we were coming back from the function, a heavy vehicle truck was coming from the opposite side without using deeper light. At that moment, Vishnu Jyoti Pathak, who was sitting on left front seat of the car, being afraid, pulled off the handbrake of the car and jumped out from the car, as a result of which Vishnu Jyoti Pathak sustained injuries. Thereafter, the car lost its balance and suddenly turned to the right, and then the left rear portion hit a tree on the back side of the car was damaged. Due to this, all the travelers of the car sustained injuries. This is my lord PW3 and I'm sorry, DW3, my lord. And DW 4 also, my lord. He also deposed in the same line.
What was the cross-examination?
My lord?
Cross-examination.
Cross-examination part, my lord, page 148. On the date of accident, I was in the back seat. Vishnujyoti Pathak was also proceeding in the vehicle. The vehicle hit a tree. All occupants sustained injury. I have not filed case. Vishnujyoti died later on due to accident. I do not know the number of the truck. I depose for my friend. It is not a fact that front side of the vehicle was damaged. I did not say anything to police. It is not a fact that I have deposed falsely. This is the cross-examination. Nothing has been, my lord, rebutted in the cross-examination also, my lord. And my lord, DW4, page 150, he also, my lord, reduced the evidence, my lord, on the same line.
In the same line.
My lord.
His cross-examination
His
on same
cross-examination,
line.
page 153, my lord. I was present in the vehicle on the relevant day. The further course, same as DW3. Nothing is there, my lord. Only one witness, my lord, he supported the case of the prosecution, a claimant, that is PW2, at page 102, my lord.
So the question is whether he has to be relied upon or the defendant's witnesses.
If the, my lord, independent witnesses is to be counted, then the, my lord, out of 3 independent witnesses were, my lord, occupying the vehicle, 2 has adduced evidence in favor of the, my lord, appellants. 1 has adduced evidence in favor of the, my lord, claimant. And the from, my lord, photographs of the vehicle, it is clearly evident that the vehicle was damaged from the back side, not from the front side. Had the, my lord, deceased person was sitting in the vehicle without jumping out from the vehicle, he would have, my lord, sustained maybe, my lord, minor injuries, but he would not have died.
Okay.
And
Anything else?
my lord, in the criminal proceeding, my lord, Rosimi kindly turn to page 10 of the pilot judgment, paragraph 14. Evidence of, my lord, the PW2 has been discussed in the criminal proceeding, my lord. Paragraph 14, my lord, I'm sorry. Paragraph 14, page 10 of the, my lord, the judgment loose copy, my lord, GR case, my lord.
Yes.
Paragraph 14. PW7 Papumunda is one of the victims of the alleged incident, and in his evidence, he stated that in the year 2015 at about 2 a.m., the occurrence took place at Jorabari FCI Godown. On that day, he, the accused, Kaushik Soikia, Dhon Soikia, and Vishnujyoti Pathak were proceeding towards Narayanpur. The accused was driving the vehicle and he was sitting on the backside of the vehicle, and as such, he could not see as to what had happened. The road was in broken condition. He saw a truck coming from the opposite direction. Both the vehicles were proceeding in speed, as a result of which the accident took place. Their vehicle struck a tree by the side of the road. He came out from the car and became unconscious. He received injury on the backbone and hand, leg, lost consciousness. He was also taken to Gauhati for treatment. The evidence of PW7 goes to show that he was sitting on the rear seat and he did not see why the occurrence took place. Though this witness stated that their vehicle was proceeding at speed along with the vehicle coming from opposite side, but remained silent that their vehicle was driven at such a high speed which resulted in the accident. Admittedly, the occurrence took place at the national highway and therefore it is expected that the vehicle fly at high speed. The road near the place of occurrence was full of potholes and it is quite obvious that such occurrence may take place due to bad road condition. This evidence also does not go to show that there was rash or negligent driving on the part of the accused.
No, by showing this evidence, what you want to submit?
My lord, by showing this evidence, I want to draw your lordship attention that appellant number 2, who was driving the vehicle, he did not drive the vehicle in a rash and negligent way. Accident took place due to the negligence on the part of the deceased, not due to the negligence on the part of the driver. And if the rash and negligent driving of the driver is not proved, claim petition itself is not maintainable.
Okay.
Except the asset to Mandora. 2012 4 SCC 552. Possibly kindly peruse the paragraph 8 onwards, my lord. The claimants are the parents of the deceased person. The deceased was a doctor by profession. The deceased was traveling in the motor vehicle driven by the respondent number 1, who happened to be a close associate friend. It has come in the evidence of the claimant as well as the respondent number 1 that the vehicle in question was not driven in a rash and negligent manner by the respondent number 1. Admittedly, the petition filed by the claimant was under section 166 of the Act and not under section 163A of the Act. This is not in dispute. Therefore, it was the entire responsibility of the parents of the deceased to have established that respondent number 1 drove the vehicle in a rash and negligent manner, which resulted in the fatal accident. Maybe in order to help respondent number 1, the claimant had not taken up the plea before the tribunal. Therefore, the High Court was justified in sustaining the judgment and order passed by the tribunal. We make it clear that if, for any reason, the claimant had filed a petition under section 163A of the Act, then the dicta of this court in Osnuma Begum would have come to in the assistance of the claimant. In our opinion, in our view, the issue that we have raised for our consideration is squarely covered by the decision of this court in Oriental Insurance Company Limited. In the said decision, the court stated, therefore, the victim of the accident or his dependent have an option either to proceed under section 166 or of the Act or under section 163A of the Act. Once they approach the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on part of the owner of the vehicle or the driver of the vehicle. We are in agreement with the principle stated by this court in the aforesaid decision. In view of the above, in our opinion, neither the tribunal nor the High Court has committed any error whatsoever which would call for our interference in the appeal by the parents of the deceased. Accordingly, we reject the appeal. However, we direct that the amount paid by the respondent insurance company by way of interim compensation under section 140 of the Act shall not be recovered from the appellant by the respondent insurance company. This is one, my lord. The other judgment, my lord, I am relying on, my lord. This is extra copy as well. 2005-13 SCC 694. I'm giving judgment. Small judgment, my lord. Paragraph 2 onwards, my lord. The accident is alleged to have taken place on 18/9/1988. When Abdul Qadir, who was going on a bicycle, is stated to have been hit by the bus owned by the respondent corporation and driven by respondent number 3, the driver. The case of the appellant was that the vehicle was being driven in a rash, reckless, and negligent manner, as a result of which the aforesaid Abdul Qadir sustained serious injuries, including head injuries, resulting in his death. The tribunal as well as the High Court have considered the evidence on record produced on behalf of the claimant and the respondent, and they have concurrently recorded the finding of the fact that the bus at the time of the accident was stationary, and it was the deceased who came on the bicycle in a rash and negligent manner and hit the bus. The cycle struck the front bumper of the bus, as a result of which the deceased fell down. As a result of the impact, he suffered skull injuries, which resulted in his death. We have heard the counsel for the parties. We have examined the evidence on record. There is evidence of 2 passengers who have deposed that the bus was stationary when the deceased came on his bicycle in a rash and negligent manner and hit the bus, which was stationary at the stop on the road signal at crossing. We find no reason interfering in the concurrent finding. There is no merit. Regarding appreciation of evidence, my lord, one judgment I am relying on, my lord, that is 2017 8 SCC 603, my lord.
Yes.
So copy this. Paragraph 13. In our considered view, in order to appreciate the factual and legal controversy involved in the list which was expected of was that order which decides the list between the parties should have contained the brief facts of the case, so as to know as to how the factual controversy arose and the ground on which the action is impugned, the stand of the parties impugning and defending the action, the submission of the parties in support of their stand, legal provisions, if any, applicable to the controversy involved in the list, and lastly, the brief reasons as to why a case of one party deserves acceptance or rejection, as the case may be. In the impugned judgment, my lord, no reason has been, my lord, cited by the learned tribunal regarding discarding the evidence of the defense evidence. Paragraph 18, my lord. Be that as it may, the High Court erred in not according any finding, much less reason finding, keeping in view of the stand of the parties taken in the pleading and the grounds of appeal. The High Court also erred in not pointing out as to why the order of the district judge is legally sustainable, calling no the appeal. Then it should have recorded finding by dealing with all the issues arising in the case. It was, however, not done, and hence it calls for interference by this court. In the light of the foregoing discussion, we cannot countenance the approach of the cryptic reasoning of the High Court and are therefore constrained to set aside the impugned order and remand the case to the High Court for deciding the appeal afresh on merit in accordance with law. So, look, my basic, my lord, argument in this case, first of all, the claim was not maintainable at Gauhati, at both parties hails from my lord North Lakhimpur, and the accident took place within the territorial jurisdiction of my lord Motor Accident Claim Tribunal Lakhimpur, not Gauhati. And though it was my lord recorded in the my lord claim petition that the claimants were residing in Mirzapur, there is no evidence on record regarding their residential status at Malad Mirzapur, nor Malad oral or Malad documentary. That is one. The other ground is that, my lord, no negligence has been proved. No negligence has been proved by the claimants. So, my lord, if without proving the negligence, my lord, as the application was filed under section 166 of the Motor Vehicles Act, my lord, no claim can be entertained. The other ground, my lord, the evidence of the DWs was not properly appreciated by the learned tribunal, and without giving any reason, the evidence of the defense, my lord, was discarded. This is my humble submission.
Yes, Mr. Acharya.
May I please? Also regarding the first point was regarding jurisdiction, territorial jurisdiction. In our claim petition, we have stated we are staying temporary staying at the present at Kamrup district. This plea has not been taken by them in their WS, neither in their cross-examination. Throughout the trial, they have never taken this plea. Territorial jurisdiction has to be taken in the first instance lawsuit. Lawsuit may be aware of it. Now in the appeal state, whether they are permitted to take the stand. They have never challenged that we are not staying at temporary staying at Gauhati under Kamrup district. In in the WS also there is not a whisper of objection on that point. So on my humble submission, this point cannot be taken over. This point cannot be a point for rejection of my claim. Second, they have taken the GR case. Gossip, the GR case record was not put on record. It was never exhibited. It has come afterward. Anything which is not recorded, how can a tribunal come to a finding? Moreover, the evidence which they have read in the GR case of PW1, Papu Mundan. Nowhere the Papu Mundan has said the disease says pull out the brake and follow. He said, even if that is taken into account at GR case evidence, he said that he was in the back seat. He did not see properly. Both a vehicle with a high speed and our vehicle got heated. Lost it. So basically, he has also not said that there was any negligence on part of the disease lawsuit. And he has stated that both the vehicle and the high speed. High speed itself is under MV Act, under 60, running in a high speed is also a negligence. Moreover, this GR case record has not been put into in the trial court. So that record also cannot be taken into account. Moreover, I don't have the judgment now. There are many judgments. The finding of the criminal case has no effect on the MV Act. So the tribunal can come to its own finding without being get affected or carried away by the finding of the criminal cases. Lordship, next point, what they were taking regarding the DW 3 and 4.
Yes.
If your Lordship allow, I like to take Lordship to the page number 50 of the appeal memo. That's charge sheet. Lordship got page 50. Type copy of the search.
Yes.
Lordship, the charge sheet is against Atul Pathak, appellant number 2, opposition number 2, the diver. If Lordship go to the list of witnesses provided at para 6, number 4 is Papu Mandal, PW1, the witness which is supporting my case. Number 5 and 6 are the DW4 and DW5, whom they are relying on. So all the witnesses are charge-sheeted witnesses, Lordship. If your Lordship go to the next page 51, last para, it is given. During the course of investigation, the place of occurrence was visited. Police has visited place. A sketch map was drawn, and after interrogating the witnesses, as evidence were found against the accused so and so, a case under section so and so was registered and charge sheet has been submitted before this honorable court for necessary trial. So all the witnesses were interrogated. After getting the evidence from all the witnesses, they found sufficient evidence. So the charge sheet has been submitted against the present appellant number 2, Lordship. So police has interrogated DW4 and 5 also. After getting the facts of the case from DW4 and 5, thereafter also they have submitted charge sheet against Mr. Atul Pathak, the present appellant. Now I would like to take the Lordship to the cross-examination of DW4 and 5, which they have already read. It is given at page DW3, page 148.
Yes.
On the date of accident, I was in the back seat. Vishnu Jodi was also proceeding a vehicle. Vehicle hit a tree. This fact is admitted. All occupants sustained injury. I have not filed case. He has not filed a case. Vishnu Jodi died later on due to accident. I do not know the number of take. I disposed for my friend. So he has admitted he has disposed for himself. So he is an interested witness. He is not an independent witness.
No, if he is an interested witness in criminal case and he is an independent witness in civil case, is it your...
Lordship, in his evidence also, in page 145, he has in para 12, I have this. The deponent is a friend of opposite party number 2. He has admitted, I am a friend of opposite party number 2.
So what is your submission? His deposition should not be relied upon.
One party says he has agreed that he has come for the in support of his friend, OP number 2, Mr. Diver. Second part, it is not a fact the front side of the vehicle is. This part, next part is important. I did not say anything to police. He is charge-sheeted. Police have interrogated him. He has not told all this in the whatever he has told in the evidence to the police. That means all the part whatever he has told that the claim that he himself have put the brake and jump out. All these are concluded make out story later on. If it was not a that, he could have told it in the told to the police in the first instance only. When the police in the first instance interrogated him and took his evidence. He has never told. He himself admitted. I did not say anything to the police. So he has hidden all this fact. Now in later on, when the case trial is going on, then he gives the evidence. No, the disease himself was got afraid, pulled the handbrake. and jump out of the car. And same thing is for PW4, DW4, because DW4 the further cross is same as DW3. So I say that all the facts, the statement state, the evidence has been afterthoughts. Because police has, after interrogation, after taking their version, has filed a search sheet against the driver of the vehicle. And nowhere in the search sheet or anywhere FIR, it has been mentioned that there is some negligence on part of the disease, this business also. Nowhere it has been mentioned also. Regarding, they are saying the only front side should have been damaged, only the back side has been damaged. Loss if suddenly a brake is appear, the car can turn right. It's not required that the handbrake has to be required. If you sharp brake is normal brake is also good, the car can turn right and get hit in the back side. Moreover, losses, I want to take the loss to the MV report, certified copy of the MV report. Certified copy of the MV report. Page 68, losses. Lots of got it.
Yes.
60. Para 9A, damage to, due to the accident. Vehicle WS damage, all doors and glass damage, all doors, not only black doors, all doors. Car body, doors, frame badly damaged. Vehicle chassis is in the front part. Engine suspension, steering portion damaged. All these are in the front part. Outwardly, the back portion got more damage, but internally, the front portion got the hit, main hit, and got damaged. Cock mountain, brake mountain damage. Vehicle dashboard seat, where the disease was sitting, dashboard seat entirely damaged. The maximum impact was on the vehicle dashboard seat because, and it was got extremely, and he was sitting there. So the disease got fall down and got died. Disease was sitting at this vehicle dashboard seat. Front bumper, side bumper, major damage. This is a certified copy of MVI. This is done by the third party. As by the MVI report, the whole vehicle was damaged, and there was huge damage in the front part. Photograph has been given only of the outer portion. Inner portion photograph they have not given. Very cleverly, they have not given the inner portion. Internally, the front portion was badly damaged. Mainly the seat where I missed where the disease was sitting. Due to this high impact, I was grievously injured and I died. Lost it. So their contention there, only the back portion is hit. If the car hit the tree, how only the back portion is hit? That is not true. The front portion is also got damaged badly.
Okay.
Lost it. So, lost it. Moreover, I like to cite only one judgment of our Honorable High Court. They have cited two cited the ration negligence has to be proof loss regarding. For GLT 516. Godavari, Davis, Sharma and others versus United India Insurance Company and others. I could like to take the lordship the para 13 and 14. May I
Yes.
in para 13, in view of those judgments, let us now scrutinize the finding of the learned tribunal so far as related to the finding of contemporary negligence. Learned tribunal has neglected the evidence suitable to a hearsay evidence. It is not considered that investigating officer of the case made his statement on the basis of matter character during the investigation, and such it is as submitted on a culmination of investigation. What he stated is on the basis of his investigation into the accident in question. As such, his evidence cannot be discussed as hearsay evidence. PW2 is the here to regarding such it. PW never claimed that he witnessed the event, or his statement is based on one individual witness. As such, finding of contemporary negligence cannot be allowed to stay. Moreover, While conducting the inquiry into claim under section 166 of MV Act, tribunal is not expected to search for proof or evidence beyond reasonable doubt. In criminal case, it has to be reasonable doubt. Later, it is preponderance of probability, which is a tool for assessment of evidence. Tribunal can find at its finding on prima facie matters such as first information report. Here, first information report, FIR, such all point to the negligence of the driver. Arrive at a finding on prima facie matters such as first information report to presume existence of certain fact in absence of other evidence which might debase such presumption. In view of this finding, that that has been written by another tribunal under contribution reform by state aside. Lordship, in MBA case, what my submission is, we do not have to prove beyond a reasonable assumption. The finding the lodging of FIR and such is itself is a proof of rational negligence has been. So rational negligence has been proved by the claimant, duly proved by the claimant. The judgment they have given, the rational negligence has to be proved. I said that are not helpful at this measure because we have already proved the rational negligence. Filing of the SARC itself is a proof of rational negligence by the driver, and they have not challenged the SARC or the FIR lawsuit.
Okay.
So as per my humble submission, the tribunal has done not wrong. We are entitled for the compensation, just compensation as given by the tribunal.
Heard Mr. I.H. Saikia, the learned counsel for the appellant. Also heard Mr. B. Acharya.
A. Acharya.
A. Acharya, the learned counsel for the claimant / respondent. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellants, namely Ulendra Pathak and Jitendra Pathak, impugning the judgment and award dated 30/6/2017 passed by the Motor Accident Claims Tribunal number
1.
Motor Accident Claims Tribunal number 1 Kamrup in MSC case number 791/2015, whereby who was directed to pay? Both, whereby the appellants were directed to pay a compensation amount of rupees 29,82,000 along with an interest at the rate of 7% per annum to the respondents / claimants. The facts relevant for consideration of the instant appeal, in brief, are that on 31/1/2015, one Vishnu Jyoti Pathak was traveling in a vehicle bearing registration number MH14 BX1288 from Pathali Pahar to Sarai Doloni. Stop. When the said vehicle reached near Jorabari, it met with an accident when it dashed against a roadside tree, as a result of which the said Vishnu Jyoti Pathak sustained injuries and later on succumbed to his injuries. It is further relevant to note that at the time of the accident, apart from the deceased, 3 other persons were traveling in the ill-fated vehicle. The deceased was sitting on the front seat beside the driver's seat, whereas who was driving the vehicle?
Number 2, my lord.
Whereas the present appellant number 2 was driving the vehicle. And appellant number 1 was also there? No.
Number 1 is the, my lord, owner of the vehicle.
Oh, appellant number 2 was driving the vehicle. Stop. Later on, the present respondents / claimants, being the dependents and legal representative of the deceased, filed an application under section 166 of the MV Act before the Motor Accident Claims Tribunal number 1, Kamrup, Gauhati, seeking compensation for death of the late Vishnu Jyoti Pathak in the aforementioned vehicular accident. Stop. The aforesaid application was registered as MAC case number 9791/2015. The opposite parties, including the present appellants, contested the case by filing the written statement, wherein the owner of the vehicle took the plea that he has already sold and transferred the vehicle, the ill-fated vehicle, to the appellant number 2. However, his name could not be transferred. However, the registration certificate of the offending vehicle still bear his name. It was also contended in the written statement that the accident occurred due to the negligence of the deceased himself, as he was sitting in the front side of the vehicle and pulling off handbrake. You took this plea.
Yes, my lord.
And he
In the cross-examination,
and
PW2 also, my lord. Yes.
and when he saw a heavy vehicle coming from the opposite direction, he became nervous and pulled the handbrake of the car in which they were traveling and also jumped outside the vehicle, as a result of which he sustained injuries. On the basis of the pleadings of the parties, following issues were framed by the Motor Accident Claims Tribunal. Quote A from page number 158. Start. During inquiry, the claimants examined 3 witnesses in support of their contention, whereas the contesting opposite parties examined 4 witnesses in defense of their case. However, by the judgment which has been impugned in this appeal, both the issues were decided in favor of the claimants, and they were awarded the compensation in the manner as already described in the foregoing paragraphs. Stop. Mr. I.H. Saikia, the learned counsel for the appellants, has submitted that the impugned judgment passed by the Motor Accident Claims Tribunal is bad on the ground that the tribunal, the Motor Accident Claims Tribunal, Kamrup Gauhati, had no jurisdiction to entertain the application under 166 of the Motor Vehicle Act, inasmuch as the said accident had occurred inasmuch as he submits that the accident in question occurred within the territorial jurisdiction of Lakhimpur district, and the second point,
The claimant as well as the opposite parties, all are residents of Lakhimpur.
as well as the claimant, as well as and the opposite parties were all resident of Lakhimpur district. He submits that the contention of the claimants in the claim petition that they temporarily resides at Mirzapur within the jurisdiction of the Motor Accident Claims Tribunal number 1, Kamrup, could not be substantiated by adducing any documentary evidence.
One more thing, my lord, case 36. It is their case that they are residents of Lakhimpur, my lord. In their evidence, PW1 is the claimant. In their evidence, she stated, my lord, they are resident of my lord Lakhimpur.
He further submits that rather in her testimony before the tribunal during the inquiry as PW1, the wife of the deceased,
Mother of the deceased.
the mother of the deceased, that is PW1, has stated that she is the resident of
Village Sorai Doloni.
Village Sorai
Doloni. PS Narayanpur.
Police Station Narayanpur under
District Lakhimpur.
Lakhimpur district. He submits that the tribunal failed to take into consideration the issue, the fact that it lacked jurisdiction to conduct the inquiry, and he therefore submits that the claims petition filed by the claimant before the tribunal is hit by embargo of section 166 within bracket 2 of the Motor Vehicles Act 1988. Stop. Next para. Learned counsel for the appellant also submits that the tribunal also erred in not appreciating the evidence on record in its proper perspective. He submits that the tribunal relied on the testimony of PW2, that is Papu Munda, who was one of the occupant of the vehicle when the accident occurred. However, it did not consider the testimony of other independent witnesses on record, namely DW3 and DW4, who had categorically deposed before the tribunal that it was the deceased who had pulled the handbrake, as a result of which the vehicle skid and its backside hit, its backside got damaged after hitting a roadside tree. He submits that the tribunal has mentioned no reason for discarding the testimony of DW3 and DW4. He further submits that in the connected criminal case filed against the appellant number 2, that is, which was registered as GR case number 313/2015, he has been acquitted of the charges under section 279/338/3048/427 of the IPC. Learned counsel for the appellant has produced a photocopy of judgment dated judgment dated 18/11/2022, passed in GR case number 313/2015 in support of his submission. He further submits that in the criminal case, that is GR case number 313/2015, the PW2 Papu Munda was also examined as a witness, in that case as PW7. He submits that before the criminal court, the PW7 has deposed that as he was sitting on the backside of the vehicle, as such he could not see as to what happened and what caused the accident. He only saw a truck was coming from the opposite direction. Learned counsel for the appellant further submits that you referred one more paragraph from this judgment.
Paragraph 18, madam.
Learned counsel for the appellant further submits that in paragraph number 18 of the judgment passed in GR case number 313/2015, the Court of London Judicial Magistrate First Class, while acquitting the appellant number 2 from the charges leveled against him, has also observed in paragraph number 18 that there is no evidence on record to come to the conclusion that the accused within bracket present appellant number 2 was at fault due to which the accident occurred. Rather, it was observed that the evidence adduced in that case establishes that it was the victim, within bracket deceased, who pulled the handbrake while he was sitting in the front seat beside the driver. Stop. Learned counsel for the appellants has further submitted that in a claim case, in a motor accident claims case, which is registered on the basis of an application under section 166 of MV Act, it is the burden on the it is incumbent on the claimant to prove the negligence on the part of the driver of the offending vehicle. However, in this case, the claimant have miserably failed to relieve that burden. He has cited following rulings in support of his submission. Number one, Surendra Kumar Arora versus Surendra Kumar Arora and another versus Manoj Bisla and other, reported in 2012 4 SCC 552. Nav Nirman Development Consultants within bracket India Private Limited versus Divisional Commissioner and President District Sport Complex Executive Committee, reported in 2017 8 SCC 603. Muhammad Hanif and another versus HP Road Transport Corporation and others, reported in 2005 legal within bracket SC 1019. On the other hand, Mr. A. Acharya, the learned counsel for the respondent slash claimant, has submitted that the tribunal has correctly awarded the compensation amount of rupees. How much compensation was awarded?
29,82,000.
Mention it. After considering the evidence on record, and same does not warrant any interference by this court in exercise of its appellate jurisdiction. Stop. He further submits that as regards the objection regarding the jurisdiction of the Motor Accident Claims Tribunal number 1 Kamrup to entertain the claim petition filed by the present respondents is concerned, he submits that no such objection as to jurisdiction of the motor accident claims tribunal was taken by the appellants in their written statement or at any stage before the motor accident claims tribunal. He submits that it is a well settled proposition of law that any objection regarding the question of jurisdiction has to be taken in a proceeding at the earliest possible instance. However, he submits that in this case, it is only at the appellate stage the plea of lack of jurisdiction of the motor accident claims tribunal under section 166 within bracket 2 of the Motor Vehicles Act has been taken by the appellants. Hence, he submits that the objection regarding lack of jurisdiction is not sustainable at this stage and may not be considered. Stop. He further submits that as regards the judgment passed in the GR case number 313/2015 is concerned, same was never produced before the Motor Accident Claims Tribunal when the inquiry was pending before it. He submits that even at this appellate stage also, no application under Order 41 Rule 27 has been filed by the appellants to bring on record additional evidence. Hence, he submits that the said judgment, which is sought to be relied upon by the appellants, may not be taken into consideration while considering this appeal. He further submits that otherwise also there is evidence on record that the vehicle was driven at a high speed and that is enough to come to a conclusion that the driver of the offending vehicle was at fault, which caused the accident of the offending vehicle. He further submits that finding in a criminal case may not have a bearing in a claims case, which is basically civil in nature, and standard of proof in such cases is mainly on the basis of preponderance of probability, whereas in a criminal case, the standard of proof is beyond reasonable doubt. Hence, he submits that the outcome of a criminal case arising out of same incident may not have any impact in a inquiry initiated on the basis of an application under section 166 of MV Act. because of different standards of proof in both the cases. He submits that tribunal can arrive at its finding of fault on the part of the offending driver on the basis of prima facie materials such as first information report, charge sheet, and other evidence on record. In support of his submission, learned counsel for the respondent has cited a ruling of a coordinate bench of this court in the case of Godavari Devi Sharma and others versus United India Insurance Company Limited, reported in 2012 4 SCC, 2012 4 GLT 516. He submits that the evidence of DW2 and DW4, DW2 and 4,
3 and 4.
3 and 4 was correctly discarded by the tribunal as they were interested witnesses, and in the connected criminal case, those witnesses have categorically deposed that they have deposed before the court as friend of the accused person. Hence, he submits that the tribunal was right in discarding their testimony. Anything else?
Also, and I told that police, after interrogating them, has filed a search sheet. And in their cross-examination, they have said that they have not told anything to the police. So I was popular story.
Learned counsel for the petitioner. Where they have not told anything to police when in GR case or in
MV case. In the process in the process examination
learned counsel for the appellant, learned counsel for the respondent has further submitted that the testimony of DW3 and DW4 was also discarded by the tribunal because during their cross-examination, they have stated
148, my lord.
They have stated that they did not state anything to police, whereas from the charge sheet laid against the appellant number 2 in GR case number 313/2015, it appears that police submitted the charge sheet after examining all the listed witnesses in the charge sheet. He submits that this shows that the story of the deceased jumping out of the vehicle is a concocted story made only to escape the liability of paying compensation to the claimants. He therefore submits that this appeal is liable to be dismissed. Stop. I have considered the submissions.
There's one point regarding MV report.
He further submits that the report of the MVI also shows that the vehicle was internally damaged on the front side also, badly damaged on the front side also. The dashboard, the steering, and all the doors were,
And my seat, particularly my seat was badly damaged.
and the front side
Dashboard seat.
seat were badly damaged, which itself indicate that there was rash and negligent driving by the driver of the offending vehicle. Anything else? I have considered so and so. I have also considered, I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Judgment reserved.
The MBA report does not say that the front seat was damaged.
No, he is saying, I am only mentioning his statement. I will go through the
Record. And everything in the records. The 161 steps is also not.
remaining, he read the remaining matters will be shown as leftover. And if you need a date, the court master will give a date. It will be in the month of June only. Because before June, we don't have any slot.
My case, Lordship, is last 4 occasions. Same thing is going on.
No, but we are helpless.
Item number, my lord, 34, my lord. 34, my lord. We amicably settle before the, my lord, mediation. my lord.
That we will take early.
Yes.
Item number 34 next week at the date.
Lordship, in item number 19, the respondent,
Obliged, madam.
the decree holder is around 85 years of age. Lordship, file an application for this early hearing. Accordingly, it is listed.
That you
Can it be taken
take a
on-
date
Yes.
as early as possible, according to our board.